Well, that's before my different continues. Well, I just wanted to know what the lay of the land is. Well, after this, will Tamil Nadu have to respond, or are you going to hear Maharashtra and others?
We hear the round of the petitioners, and everything should be concluded by tomorrow. What we intend to do is, and we also intend to tell the court officer.
No. I'm talking about my response.
We not to put the alternate list tomorrow. Well, we're going to go and it will be over by tomorrow. We hope that it will be over.
That's the other side, Manoj.
No, the whole of it. Otherwise, what will be? We will go on. The wholesome way of doing it is petitioner side is over to the respondents.
I just wanted to know that, Manoj. If that's what you're.
So you don't have to, if you are saying that you want to go somewhere.
No, it's not that, Manoj. What is, there's a partnered matter.
Today, because let them be over. That's the petitioner side.
Well, I can reply tomorrow morning if your lordships give me a chance. Yeah. I can reply in the morning at 10:30, Manoj. Yeah. If your lordships will allow me to do that.
Because in any case, the Constitution Bank not see.
Should not go in. I mean, we have no problem, but the lawyers have put it difficult.
Lawyer doesn't know when this pen will collapse, not collapse. He's having a list of what he had on board.
That's an outrage.
This can collapse. I don't mind anything, Manoj. I just want a chance tomorrow morning at 10:30.
Petitioners argue, your lordship knows, Mr. Luthra and Mr. Diwan have argued one, and they've not argued on dignity at all.
So whatever it is,
so we can finish by tomorrow. There's no.
It should be over today.
No, there are at least another 5-6 councils.
Whoever it is, they'll have to conclude today. This we cannot go on like that.
Very difficult, my lord.
You have to supplement it with written submission.
It's very difficult to do it because this is a sui generis.
That's right.
It's a matter which is sui generis.
We have heard, we have to also regulate the
kind of seminar is what is, my lord. And the lordships have asked so many questions, they have to be answered.
Great respect. Judgment passed by the Honorable Court was stayed with the Madras High Court against which Justice Radhakrishnan himself filed a petition which is pending before the three-judge bench. That also can be listed along with
whatever is listed before us, that is good enough for us. You argue. Go on. Otherwise, go on.
matter goes to the root of Nagarajan itself.
You go and you argue.
All I was saying is I should be given a chance. Oh God.
We'll consider hearing depending on. Giri, go on. Please, you go on. We are telling you, we are not going. No, you go on, and you are also conscious of what we have said.
Yes. My lord, therefore, my lord, I realize, my lord, I did not convey what I wanted to convey correctly. It is not my submission that your lordships would be called upon to consider either the quantitatively or qualitatively the legislative facts which were there before the legislature, before they enacted this legislation. That is not my intention. No, my lord, that is not something which your lordships ever do. It is not done. The submission, my lord, is that every facet of, my lord, every facet of the aspect by which this legislation is sought to be sustained, either on the ground, my lord, my lord, repugnancy or absence of repugnancy, as the case may be, or that it is for the purpose of upholding culture and heritage of the state as such. Every fact of it, my lord, is not a legislative fact, but it actually has transformed into an adjudicated fact. That is what I want, my lord, to submit. Had it remained in the realms of a legislative fact, my lord,
it is already argued by the UN. Because you supplement it, you can say.
I notice supplement.
Inherently, it is cruel. We just articulate so that you can cut down.
No.
It is the act itself is inherently animal.
That's not.
That it can never be done.
That's not
what you may do. You cannot do it. So that is changed. That cannot be changed.
Just give me some time so that I develop it and leave it. I'm not repeating whatever has been stated. Can you bear with me for just 10-15 minutes? I'll just place this, and then your lordships may consider whether it is to be developed in more detail. No, my lords, please come to what I'm respectfully submitting is this. Please come to Nagaraj. the one fact, my lord, which will be put forth in my respectful submission is that this legislation seeks, my lord, to uphold the culture and heritage, my lord, of the state. Now, this was one aspect, my lord, which was pleaded as an argument on behalf of the state before Nagaraj. And at any rate, it was considered and there is an adjudication on that aspect. I will not read it again before your lordship due to lack of time, but please take paragraphs 53 to 56 on.
That was all.
Therefore, I am not reading it. Therefore, 53 to 56. So, the preamble to the Act in the statement of objects and reasons says that it is to uphold the culture and heritage of the state, and that is why certain bulls are bred, and this is why the Jallikattu is also being held.
After the Nagaraj, it is not available to them to say that.
That's what I wanted to say. Because it's an adjudicated fact. It is not something, my lord, which will still remain in the realms of a legislative fact insofar as the legislature is concerned. There is a striking similarity between the statement of objects and reasons of the 2009 Act, which was looked into by Nagaraj, and the present enactment. But for the fact that this is now projected as an amendment to the PC Act, well, which is probably one way of saying that there is no repugnancy between this Act and the Central Act as such.
Therefore, what we thought was,
Yes.
you see, ultimate questions perhaps might be,
Yes.
whether Jallikattu in any form
Yes.
can be performed, allowed, or Jallikattu in any form cannot be done.
Lord,
Jallikattu, in other words, with
Verse 6.
safeguards which take care of the welfare of the animal involved, takes care of the human beings involved, whether the legislator in its wisdom, which normally we are subservient to, even in our judicial function, we do not say, no, we've got better wisdom.
No, you're not.
That is going to be the question.
Yes. No, my lord, let me respond to this. Jallikattu in a form that is modulated, that is regulated, or that is not possibly to be monitored in the manner as projected by the state, is it permissible? Or Jallikattu in all forms, whatever it is, or Jallikattu in all forms, whatever it is, as it should be banned, as Nagaraj has said. It's not a question which is it's not capable of one statement answer as such. But let me put it this way. The manner in which Jallikattu was sought to be regulated, or it could be not permitted, was put forth, my lord, in Nagaraj. My lord, why I keep coming back to that is because the Jallikattu by itself, my lord, has been the manner in which Jallikattu is to be conducted and why it is conducted. These were all matters, my lord, which were placed for adjudication before the Honorable Court. It is not anybody's case, let alone the state, and that is to be reflected, my lord, from a reading of the legislation. The Jallikattu in this form is permissible. Jallikattu in this form was never the subject matter of adjudication by the Honorable Court early. Jallikattu per se, my lord, according to them, amend section 3, amend section 11.3, amend section 22, amend section 28. Jallikattu is therefore taken out of the purview of the PCI.
Along with the change in the rules.
My lord, rules are subordinate rules. My lord, the validity of the legislation cannot be tested or cannot be defended, my lord, by a reference to the subordinate rules which are framed by the state and are not legislative in character in the sense that they cannot be elevated to the status of a plenary legislation. Question of repugnancy, my lord, arises. Question of repugnancy does not arise in the context of a subordinate legislation. Question of repugnancy always arises in the context of a plenary legislation. In the context, my lord, of the subordinate rules, the challenge is on the ground that either it is ultra-vires, or that it violates a parent statute, or it violates Part 3 or any other constitutional provision. Repugnancy question, a test of repugnancy always arises in the context of a plenary law. And that is what is being put forth.
Yeah.
My lord, if your lordships kindly come to, my lord, this is one aspect of it, and therefore, my lord, read with the rules as it now stands, or, my lord, which rules according, as your lordships were pleased to observe, have made a seminal change from the rules which were there under the 2009 Act, will really not take the argument forward insofar as, my lord, the question of repugnancy is concerned. If the provisions of the Act Because after all, my lord, it is under the amended provisions of the Act that the rules are framed. No, my lord, if I want to challenge the rules, I can possibly challenge the rules. If I want to challenge, my lord, the conduct in which, manner in which, my lord, Jallikattu is now being conducted from year to year, specific instances, probably, my lord, I could do it. But, my lord, when I challenge the rules, and the rules are propped up by saying that these are not ultra-wise the provisions of the Act, then, my lord, I'll have to show specific instances where my lord, the provisions of the rules have been violated. But that is not, my lord, an argument on repugnancy. In my respectful submission, 254, argument of repugnancy, judicial usurpation of judicial power, legislative usurpation of judicial power. These are all, my lord, have been laid down by your lordships only in the context of a plenary law versus a plenary.
Yeah.
Not in the context, my lord, of rules which are framed, subordinate rules which are framed, and, my lord, which have to be tested on the anvil, which I just now, my lord, submit before your lord.
Yeah.
No, my lord, the further argument, my lord, I'm hurrying, my lord, because your lordship has said this. I just wanted to present what I respectfully submit would be a different facet to this. No, my lord, if your lordships kindly come to the PC Act, kindly have a look at the PC Act, my lord, the PC Act. Lordships have been taken through the objects and reasons to the main Central Act. When your lordships read the Prevention of Cruelty to Animals Act, your lordships would obviously have in mind entry 17 of list 3, which says prevention of cruelty to animals. That is what this act is intended to be. And that is what, my lord, it states in the statement of objects and reasons as well.
Yeah.
But please come, my lord, to section 3. Once your lordships read the main act, it shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. Added to it is the Tamil Nadu amendment which is under challenge, notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations as may be framed by the state government shall be permitted. No, my lord, this is one. No, my lord, this by itself, my lord, would probably be inadequate. Therefore, my lord, they come to section 11.
Yeah.
Now, if your lordships have a look at section 11, 11.1 deals with treating animals cruelly. Each one of the subsections, my lord, of subclauses of subsection 1, beats, kicks, overrides, overdrives, overloads, tortures, etc., etc. Each one of them, my lord, has been treated as statutorily treated as acts amounting to cruelty. Each one of them.
Yeah.
No, my lord, then your lordships will come to subsection 3, because the amendment is in subsection 3. Amendment is not to section 11.1.
Yeah.
What therefore the Central Act behoves as acts amounting to cruelty in treatment of animals remains as treating animals cruelly.
One thing, sir, preparing for the state, is there power conferred on the state to make rules after even your amendment?
Yes.
My lord, only subsection 2 of section.
The amendment made to this main act,
By Tamil Nadu?
Tamil Nadu itself says that subject to the rules framed by the state.
No. Whether section 38 deals with the rule-making powers being conferred on the central government. Have you amended the Prevention of Cruelty Act?
Yes, we have.
By which may be made on the rules may be made by the state.
Yes.
Where is it?
Lord, the Maharashtra has brought in section 38B.
That's right.
Tamil Nadu has not done. Therefore, my lord, they apparently would trace the source.
We have not made amendment to the rule.
It's only under section 3.2 which says rules and regulations as may be prescribed. But if your lordship says, yes.
Power is conferred under section 38 on the central government. By a central act.
And
It
section,
is in the concurrent list. Therefore, you
And
have
section
the
three-
power to amend the act.
and section 3, which has been added, but not amended,
Yeah.
that itself provides that
No,
the
no,
state
but that
can make.
doesn't confer the power to make rules on it.
It doesn't.
It does, bro.
I wanted to bring to your lordship's notice.
That does not confer power on you
Doesn't.
to make rules, which is why the Maharashtra government has in fact specifically amended it.
Yes.
And rulemaking power must be conferred.
Lord, Maharashtra has some.
Maharashtra, that proves the point.
But both Maharashtra and Tamil Nadu have not amended 38 at all. That's
If
not.
you if you don't amend the rule, how do you make the rules in the first place? And if you don't make the rules, it's a package with.
Lord, I checked up. I wanted to make this up. Whenever I checked up, Lord, the answer.
Section 3,
says so.
section 3(2).
3(2).
Yes, 3(2).
3(2), huh?
Notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations that may be framed by the state government shall be permitted.
All right. All right.
Page Muller's 138.
That is true, that your lordships have seen.
That's what my lord asked, Muller. That's very much.
That is something which the lordships have already seen. Whether your
No,
lordships
no.
are asking whether
My lord asked
this
the
is a
question.
section analogous to section 38B of the
Doesn't
Maharashtra.
have to be.
That's not there.
Doesn't have to be.
Subject to such rules.
That may be framed by the,
state
that's,
government.
But where is the power to
Whether,
frame?
whether we put the power in 38 or not in either section, not ultimately the power should be there.
that's all.
So that power has been reserved expressly and
Artfully
specifically.
done.
Yes.
Inartfully done, not.
Malod's right, it could have been, it should have been there also, but with great respect, where the power is located would not be decisive.
Yes, yes.
My Lord, I have not reached it as a ground and therefore, my Lord, I have not pursued it further. But this was something which struck me anyway, my Lord, I leave it at that.
All right, all right.
Yes. No, my Lord, because this they could always tackle by bringing in an ordinance tomorrow saying that amending the section 38 analogous to the manner in which Maharashtra has amended it. It doesn't really cut to the root of the matter. Therefore, my Lord, I leave it at
To take care of that.
Yes, yes, yes. No, my lords, but when your lordships come to section 11(3), nothing in the section shall apply to, my lord, A, the dehorning of cattle, the castration or branding or nose roping of any animal in the prescribed manner, the destruction of stray dogs in lethal chambers, or by such of the methods as may be prescribed, the extermination or destruction of any animal under the authority of any other law for the time being, probably, my lord, there are state laws by which, my lord, stray dogs are to be, the ABC rules have been framed. There are several other laws. Any matter dealt with in chapter 4, or, my lord, C, E, the commission or omission of any act in the course of the destruction or the preparation for destruction of any animal as food for mankind unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. My lord, this clause has been the subject matter of a deep deliberation by this honorable. And therefore, my lord, there is a compendium of rules dealing with slaughtering, framed at the state level, and also framed, my lord, under the Prevention of Cruelty to Animals Act. My lord, I'll give it is all part of it.
Does it sort of harmonize
Yes.
with the injunction of the Upanishad that no being can claim superiority over another?
Yes.
Without claiming superiority, obviously you can't catch hold of whatever animal it is.
Yes.
I mean, kill it, whatever the cruel thing was, cook it, eat it.
Eat it.
So when you're talking about animal rights,
Yes.
be reminded that even the lawgiver
Yes.
has contemplated, in a manner of speaking, giving a slightly higher place to a human being. We have subordinated even the lives, because we are not cannibals. For example, you don't kill a human being. That's what you are like some of the countries perhaps in Africa. In some parts of Africa, they still have it. So we don't do that. But animals are allowed to be cooked. For medicinal purpose, you can do that. In various stages, we'll find that animals are not treated on par with human beings.
This is what I wanted to submit. This is where, my lord, I would respectfully request your lordships to kindly consider this as. Subsection 3 of section 11 and subclause E. Therefore, my lords, permits slaughtering of animals for food. The other subclauses, my
Not
lord,
only for the purpose of human, my other brother pointed out, for religious purposes, you can slaughter it.
no, religious purposes, my lord, it has not been upheld as part of Article 25. It has not been.
It has been. It is, for example, in Uttarakhand.
Bakrid, my lord, Bakrid,
She
it has
was
not
there
been,
as a
it has not been
participant, I remember.
upheld under Article 25. But assuming, my lord, that it is upheld, it still would be, my lord, part of
Not
article.
alone in whole part of Eastern India, animal sacrifice.
In all the temples,
Sacrifices, my lord, are prohibited. Animal sacrifices have been prohibited under a separate enact.
animals are being, lambs are being killed, offered as sacrifice in the temples in Uttarakhand. We are
Prohibited activity. It's a prohibited activity.
It was in fact considered by a division bench to be, and all that we said was, the division bench said was, it should be done in a slaughterhouse.
Lord, that part of it I understand. Lord, if it is done in a slaughterhouse,
Even
then
the
it
Act
comes-
says so, the Act says so.
Correct, Lord.
Act says so.
Nobody might have challenged.
What
that.
you're saying as the general refrain is that there is a perception that animals are being subordinate to our interests. When you say you can't do it, means you can't do it. That animal has got the equal rights.
No, that's
Maybe
what
it
I-
is not correct.
That's what I wanted to submit. Therefore, there is a subordination. But why is there a subordination? And why is the subordination not illegal? Because preparation, slaughtering of any animals for the food of the man, again, my lord, is probably propping up the fundamental right of man, my lord, to live under Article 21. It is traceable to Article 21. Therefore, subclause E could be upheld because, my lord, it is in perpetuation or it is in support of the right of man, my lord, to have food, which is part of the right under Article 21, right to live.
Why can't man live on land?
No, it cannot, my lord. It's a personal choice. That's a different matter, which is again, my lord, construed as a right of under part of Article 21.
Therefore,
I being a vegetarian or a non-vegetarian is my choice. It's part of my right to privacy. It is part of my right of choice, and therefore it is again be treated as under Article 21.
how do you show compassion to the animals by killing them?
No, you do not show, but you do it out of necessity, and this is what has been considered, my lord, in Nagaraj also. Each one of the subclauses under subsection 3 comes under the doctrine of necessity and then is therefore, my lord, supported by that. More so subclause E, which says that because it is food for the man. It's food for the man. There the question that there could be alternate forms of nutrition, which, my lord, in Qureshi 3, this honorable court said, had, my lord, had gone deeply into that subject is really not the answer. In my most respectful submission. I have my choice, my lord. I am a vegetarian. I have my choice. But there are persons, my lord, who need meat, my lord, for food, and they have been used to that. They have been used to that for centuries, and that is why, my lord, subclause E under the
Jallikattu is also for centuries.
no, my lord. There is absolutely nothing to show. There is no. That's my lord. That's
Brother Roy put.
Lord, my lord put it on a rhetorical basis, if I may say so. I am not, my lord, trying to put your words in your lordship's mouth. Your lordship said, somebody wants, my lord, the hand of the very fair daughter of a noble man, and this is the only way of doing it, my lord. I don't know. He could be either completely crazy, or, my lord, he could be a very brave man.
He could be besotted, not crazy.
He could be besotted,
Under,
which means, my lord, another form of craziness. That's all.
under which law this animal sacrifice is prohibited for religious purpose?
No, not for religious purposes. Religion, it is, my lord, I'm only saying about the judgment which
No,
say,
we are asking because some indication that it's for animal sacrifice.
Section 28.
animal sacrifices are not expressly permitted.
Mm.
But when it,
Is there any prohibition?
that's, my lord, under the rules. That's under the Prevention of Cruelty to Animals Slaughterhouse rules.
Not 28, section 28.
No, I'll come to section 58. No, that's a different. Nothing contained in this act shall render it an offence to kill any animal in a manner required by the religion of any community. Then it must be part of an essential religious practice. What I'm saying, my lord, is that killing of an animal, if it is part of an essential religious practice, not only is it sanctioned by 28, it probably, my lord, would therefore be protected by Article 25 also. I'm saying, my lord, that Qureshi held that Bakri or sacrifice of animals, my lord, killing of animals at the time of Bakri is not part of Article 25. Touched it, did not go deep into it, but there is no judge. There are several judgments which says that sacrifice of animals, my lord, it may not be, it would not be part of an essential, it is not a essential part of an essential religious practice. That there are. But that is not it, my lord. If it is, my lord, I am on demurrer. Suppose it is part of an essential religious practice, it gains a protection under Article 25. If it is for food, it gains a protection under Article 21. How does a sport or a sporting event or even culture and heritage, my lord, as it is touted to be, it does not have its movings under any one of the rights under Part 3.
Yeah.
No, my lords, if this be the case, then, my lords, this is where the repugnancy really arises. The amendment, Tamil Nadu amendment, takes it completely out of the purview of the PC Act, because that's what Section 11.3 says. The amendment by Tamil Nadu, both in 22, 28, Section 3 defining what is a Jallikattu, Section 2 defining what is a Jallikattu, 3 says the first part of 3.1 will not apply to a Jallikattu. Then 11.3, none of this will apply to Jallikattu. Then 22, then 28, taking Jallikattu completely out of the purview of the PC Act. This is where the repugnancy to the Central Act, my lord, really arises.
I said to the president. Answer is very clear. It is because there is repugnancy that there is assent to by the president.
The assent to the president has also been independently challenged. That's a different matter. I'm not touching on that. I'm saying, my lord,
So the
is it
repugnancy
my
goes.
lord, the first question is it repugnant? It is repugnant. Is by
Assume it is repugnant.
yes.
It is craved by the assent
Yes,
by the president.
Yes. No, my lords, the question of repugnancy has also been gone into by now. Though that I don't know whether the question of the presidential assent was there under the 2009 Act.
Nagaraja was not on the same fabric. The legislative.
No, it was not on the same
completely
fabric.
changed.
It was not part of the same fabric.
It will be a contradiction in terms you say.
Correct.
State legislature does not have the power to amend.
Correct.
That's why we gave the example. Suppose
Correct.
Parliament
Correct.
amended
Your lordships are right. Your lordships
Suppose
are right.
Parliament amended it.
Yes. No, my lord.
Another example is there.
Yes.
Yes.
No, Parliament did not amend this.
Supposing, we are telling you, supposing Parliament amended the law and brought in the same amendment,
Yes.
and Tamil Nadu brought in,
Yes.
can you say it's still repugnant?
No, then the argument doesn't arise.
Therefore, what you're saying is lack of legislative power, rather lack of legislative power. All of this is traced to entry 17, which is in the concurrent list.
No, I'm sorry.
Prevention of cruelty to animals is in the concurrent list.
Yes.
Which means what? Both the parliament and the state can make the laws, amend the laws. There is a law made by parliament, the Cruelty Act. The state legislature amends it. Power is under 17.
Yes.
So how do you say power is not under 17?
No. I'm saying, my lord, I'm not on that. I'm saying that this amendment made now is not a valid amendment because it amounts to an usurpation of the judicial power of the state. Why?
The argument.
Again, no, I'm sorry, my lord. That's not what I.
Repugnancy at all.
No, my lord. In every case, my lord, of a repugnancy, there possibly could be, my lord, an argument of this nature also. Why I wanted to bring repugnancies for this purpose? 11.3, my lord, each subsection in 11.3, each subsection, I subclause in 11.3 is rooted in some measure on some fundamental right. Not this. Not this. It cannot be on culture and heritage and definitely not a fundamental right. If it comes under Article 51GH, all right, my lord, the directive principles of state policy say that you should encourage it. But where is, my lord, the material to show that Jallikattu is part of the culture and heritage of the state from time immemorial? It is not there. No, my lords, there are two judgments, my lord, which your lordships must have seen innumerable times when it comes to, my lord, usurpation of judicial power. No, my lord, before your lordships get into that, there is one judgment on colorable legislation, locus classicus, and the one paragraph on that. If your lordships kindly have a look at 1954 SCR 1, Gajapati Narayan Dev versus State of Orissa. It's not part of the compilation. The list has been,
Who is the author of this judgment?
my lord, Justice Mukherjee, Justice B.K.
So the reference to that eco, that US decision is checked. Chinese laundryman case. Anyway, if it's not.
I didn't think so. For the nominal citation, not all these. But I'll check upon that your lordships are having.
No, that was one of the initial authority one.
Yes, still remains.
The Chinese laundryman case, US Supreme Court. Anyway,
Yes. My lord, just paragraph 9. Just permit me to read paragraph 9. I'll just take 2 minutes on.
Yeah.
Para 9, my lord, I think the paragraphs are the same. I hope so, my lord, because I got a SEC copy of an SCR judge.
Yeah.
It starts with, it may be made clear at the outset.
You have to read slowly because I'm not having.
Oh, I'm sorry. I can
No,
handle
you
it.
can, I'll follow you. Please.
No. Lord, it's, sorry.
You will have to tell us how it begins because SCR has
Lord, it begins by saying
No
it may be made clear at the outset.
yes. Page 10.
My lord's got it. The paragraph. SCR copies may not be paragraph.
No,
paragraphs
no.
may not be numbered.
No
Page
paragraph.
10, page 10,
But your lordship got the paragraph.
page 10,
Yes.
and we got the para out. Please read.
It may be made clear at the outset that the doctrine of colorable legislation does not involve any question of bona fides or mala fides on the part of the legislature. The whole doctrine resolves itself into the question of competence of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motives which impelled it to act are really irrelevant. On the other hand, if the legislature lacks competence, the question of motive does not arise at all. Whether a statute is constitutional or not is thus always a question of power. A distinction, however, exists between a legislature which is legally omnipotent like the British Parliament and the laws promulgated by it which could not be challenged on the ground of incompetence, and a legislature which enjoys only a limited or a qualified jurisdiction. If the constitution of a state distributes the legislative powers among different bodies, which have to act within the respective spheres, marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in the method of enacting it, transgress the limits of its constitutional powers. Such transgression may be patent, manifest, or direct, but it may also be disguised, covered, and indirect, and it is to this latter class of cases that the expression colorable legislation has been applied in certain judicial pronouncements. The idea conveyed by the expression is that, although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality, it transgressed these powers, the transgression being veiled by what appears on a proper examination to be a mere pretense or a disguise. As was said by Justice Duff, in so and so, where the lawmaking authorities of a limited or a qualified character, it may be necessary to examine with some strictness the substance of the legislation for the purpose of determining what is that the legislature is really doing. My lord, I'll stop here for a moment. But then, in other words, it is the substance of the act that is material and not merely the form or outward appearance. And the subject matter and substance is something which is beyond the powers of the legislature to legislate upon. The form in which the law is clothed would not save it from condemnation. No, my lords, please keep this judgment by your lordship's side. No, my lord, Prevention of Cruelty to Animals Act, my lord, fortunately, is under entry 17 of list 3. Entry 17 of list 3, please have a wording on it. First time that your lordships are really, I believe first time that your lordships are really concerned with the state amendment, my lord, to the Prevention of Cruelty to Animals. I'm not sure, my lord. First time. Now, my lord, in 7th schedule, entry 17 of list 3.
Lord, it reads as prevention of cruelty to animals. That is how the act is also worded. A state amendment, my lord, to the entire act within itself, my lord, will be slaughtered under 8370. A state amendment, my lords, which essentially permits Jallikattu to be taken out of the purview, my lord, of the main act. How does it, my lord, flaunt itself as an act which could come under prevention of cruelty to animals? That's a question which I asked to myself. Prevention of Cruelty to Animals Act 1960, the central act is clearly slaughtered under entry 70.
We'll give an example by way of answer to this, what you are saying. Supposing the original, that is 11.3,
Yes.
A to E was already there. Assume that A to C was there and they wanted to add D and E later. So what is E? E permits killing of animals for the purpose of eating it.
Rooted in 21.
No, whatever it is.
Rooted in 21.
Yes,
That's why
we are talking about, see, the point is this. We have a division of legislative power, as you know. List 1, list 2, list 3. In the case of a state making a law, it can make it either if it falls under list 2 or it falls under list 3. Now, if it falls under list 2, then the state will have its way subject to Article 246.3. Because it is subject to, in the case of any. In the case of a concurrent list, alone repugnancy can arise. It has been laid down.
This is one caveat.
And once there is repugnancy, it can be saved under 254 qua the particular state on the receipt of assent. The doctrine of colorable legislation, which you have been harping upon, relates to a conflict between a law which is made by the state legislature, pretending as if it is trying to make it under a list in list 2.
That's a classic test.
That's the test.
That's a classic test.
So if it is falling, therefore the first step you have to take is whether the law is traceable to which list. Once you find that it falls in list 3, the next thing you have to do is whether there is repugnancy. Third thing, if there is repugnancy, has President given the assent. Correct? In this case,
yes,
you should realize one more thing. The earlier
Nagaraj.
Okay. The judgment was dealing with a case of repugnancy where the state tried to put it under various state lists. It failed. This court took the view that what you're trying to do really is something which is covered by the Central Act under the Prevention Act. So impliedly the court was recognizing that if they wanted to do something of the kind which they have actually got around to doing later on in 2017, it would appropriately, properly fall within the ambit of entry 17 of list 3. So they went about doing it, and they knew that it is repugnant. Since it was repugnant, in tune with 254.2, they got assent to the president. So it's all on the, face of it, it's all very good. You may have other arguments which we are prepared to hearken to.
Can you respond? The argument, my lord, that was taken up before Nagaraj by the state were two threefold.
Yes.
One was, my lord, that it is within the competence of the state legislature. On repugnancy, they said there is no repugnancy. This is different. Entry 17 was referred to by the court while dealing with Nagaraj also. Ultimately, my lord, the legislation is sourced to entry 17. It is not sourced to entry 14 and 15 of list 2. Though the argument was advanced, it was specifically rejected, both in the main judgment as well as in the order dismissing the writ. Now, but the point is this. Lordships asked me whether, suppose a parliament had enacted this law, now that the state has done it, but hypothetically, suppose a parliament had done it, would this argument of colorable legislation, would this argument of colorable legislation apply at all? An argument of colorable legislation cannot really apply, cannot be taken up
except in respect of matters which specifically come under list even regarding any parliamentary legislation. Regarding any parliamentary legislation, the question of competence can be taken up or it can be raised as an argument only when the legislation otherwise squarely falls under list 2. Otherwise, when either under list 3 or under the residuary article of list 1, it is open to the parliament to bring about any law. The classic example is before Constitution was amended in 97A, entry was imported. The Finance Act was always sought to be supported. Mr. Sibyl would know that very well. Was sought to be supported with reference to the residual entry. Therefore, the parameters which your lordships would always employ in considering a colorable legislation. When it comes to a parliamentary law and when it comes to a state law are different. My submission is that I just put what is a colorable legislation, but the argument is this, and this argument your lordships may consider. This law, which purport itself to be an amendment to the PCE Act, and PCE Act being squarely for the purpose of preventing cruelty to animals. That's the whole object of the Prevention of Cruelty to Animals Act.
That is not. Please read, take the object of that act.
Yes.
The Prevention of Cruelty Act. Please read that.
Yes.
An act to prevent infliction of unnecessary pain.
Yes.
Or suffering.
Yes.
On animals.
Yes.
Next is relevant.
Yes.
And for that purpose.
Yes.
For that purpose to amend the law relating to prevention of cruelty.
That's a simple act.
So not for the purpose of exclusively or totally to prevent. So that is the first part. The first part says to prevent infliction of unnecessary pain or suffering of animal. So this law was enacted to prevent that.
That's because there was an earlier. There was an earlier law.
He only said the Prevention of Cruelty Act, Animals Act 1960. This was enacted for that purpose.
No, my lord, the first part of the preamble is referable to what your lordships will get it under section 11 and section 11.3. This is a manner in which, my lord, preventing and unnecessary pain and suffering, your lordships will find it in every clause here, even in E, which permits slaughtering of animals. Unnecessary pain and suffering, your lordships will find it there. The Act regulates it. The Act regulates it. That is why your lordships will find.
Not for total prevention of
no, not the.
Because see, for the purpose of invention, to aid invention, if that is used, that will not be treated as for the purpose of cruelty.
Fair enough, my lord. Unnecessary to prevent unnecessary pain and suffering.
That is why
what could be, my lord, is conduct of Jallikattu, which involves, my lord, as this honorable court has found, inflicting pain and suffering on bulls. Can it be treated, my lord, as something a necessary concomitant of, or can it be treated as a necessary pain or suffering that the animal may undergo? It cannot be.
These questions have been already raised by Mr. Diwan very extensively. And we call upon them. Anything you want to add for them, added.
No, my lords, this is one.
At the same circle.
No, I'm sorry.
So, this very repugnancy submissions, views of the legislative power exercised by the government, it is not within the scope of the ambit of the Act of 60. It has already been argued at length.
Except that, my lord, I wanted to show to your lordships 11.3 and show it that the permission that is granted under the Central
11.3 has been very extensively argued by Mr. Diwan.
Not, my lord, not with reference to Article 21. Not with reference to Article 20. That's what I wanted to, my lord. It's only another facet of the argument. It's another facet of the argument.
To give audience to all lawyers.
No, my lord.
The question is,
I'm
add something to what has been argued.
I'm concluding in 10 minutes. Okay. I'm submitting, my lord, that in 11.3, why, my lord, slaughtering of animals is also governed by the provisions of the PCA Act. It's an act, my lord, to prevent cruelty of animals, prevention of cruelty to animals. But nevertheless, my lord, it also regulates the slaughtering of animals.
It's prevented, that's a plenary legislation which deals with slaughtering of animals. That is because it is slaughtering of animals is permitted because it's food to mankind. And when it becomes part of the food, it is traceable to the man's right under Article 21. That is why it would gel with the general scheme of the Act, which is for the purpose of preventing cruelty to animals. The ultimate cruelty that one can inflict upon an animal is what? To slaughter it. But that is permissible because it is for food. That isn't gel with the general scheme of the Act. My submission is this. Keep that apart. Every provision in the main Act which says that slaughtering or which says that pain and suffering, as your lordships put it, unnecessary pain and suffering apart, that there could be pain and suffering that the animals could be subjected to, including slaughtering, is because there is a justification on a higher pedestal. That is why 11.3 cannot be found fault with. 11.3e cannot be found fault with because it is traceable to Article 21. The submission of the sequitur is this. On what higher right can the conduct of Jallikattu be rested on? Is it culture and heritage? What is the material? One. Secondly, culture and heritage was touted before Nagaraj, before the Honorable Court in Nagaraj, as something which justifies the legislation. Even in there, that's the same thing here. The format is different. No material whatsoever.
So indirectly you are saying about this is an avoidable pain.
Yes. One, it is an avoidable pain. Secondly, it is not, this conduct of Jallikattu cannot be rested on the achievement or exercise of any right which is higher to that which is already recognized under the Prevention of Cruelty to Animals Act. You have the legislative device by taking it completely out of the purview of the PC Act. Prevention of Cruelty to Animals Act squarely falls within entry 17 of list 3. You can't bring in an state amendment apart from the question of repugnancy. That's why I said it. Whether could it be done by the Parliament? I'm saying that insofar as the Parliament is concerned, probably the residual entry will come and support that. But even then, insofar as the state legislature is concerned, we are concerned with that. Insofar as the state legislature is concerned, it doesn't fall, it cannot be slaughtered under entry 17 of list 3. And the legislation is therefore bad even for that reason. Every exception that is carved out under the Prevention of Corruption Act has its roots or is predicated on the exercise of some right or the preservation of some right which can be put on a higher pedestal than the preservation of animals' rights or avoiding unnecessary pain and suffering to an animal.
Yes.
This is my respectful submission. On the question, I'm cutting it short. On the question of what could be the parameters that have to be applied in relation to the validating act. I'll just give the citations and then say what the principle is. The first one, is the original judgment of Prithvi Cotton Mills versus Brochborough Municipality, 1969 to SEC 283.
Yes.
Paragraph 4, but I'm not reading it. Lordships might have read it several innumerable times. 69 to SEC 283. Paragraph 4. Then, there is a detailed analysis of the same principle, reiterating what was mentioned in Prithvi Cotton in 97 1 ACC 326 paragraph.
It's the same proposition, if the latest for the earliest.
Sorry,
It's the same proposition.
No. I'm just giving the paragraph. I'm not reading it. Therefore, I don't want to take up your lordship's time. Yes, and the last one, my lord.
Taking our time, but in practice,
Yes. But,
the parent.
no, I'm not reading anything.
Yes.
The last judgment, my lord, which gives a conspect of all the earlier judgments on that point is 2003 5 SEC 23, paragraph 17 and 22. The nominal citation, judgment by Justice Romapal, National Agriculture Cooperative versus Union of India. My lord, the test is this.
335.
One manner in which, my lord, your lord,
Repeat that page.
page, my lord, the 2003 5 SEC 23, paragraph 17, 20 to 22. My lord, the test is only this. Has the basis of the earlier judgment been removed by this amendment? Assuming that it has removed it, is it still constitutionally valid? Is it within competence of the legislature? My lord, these are the normal parameters that are my lord, applied.
Yeah.
Whenever my lord, an act of this nature, my lord, is challenged before your lord. In my respectful submission, my lords, the finding in Nagaraj that Jallikattu inflicts cruelty upon animals is not a judgment which is predicated merely on the construction of the provisions of the act that was my lord,
Inherently good.
inherently. Yes. In which case, my lord, no amount of legislative engineering by bringing in a legislation which is a state amendment and getting a presidential assent is sufficient to get over it. My lord, the test is this. Had this amendment been available, my lord, to the bench, been before the bench when Nagaraj was delivered, would the judgment have been the same? The reasonings might have been diverse. But this reasoning, that Jallikattu by itself inflicts unnecessary pain and suffering on the animals, that finding would have still been missing. That cannot be removed and that has not been sought to be removed.
Yes.
That is not on the construction of the provisions of the Prevention of Cruelty to Animals Act alone.
Yeah.
It is not an appraisal of what the event entails. It is on an appraisal of the factual situation that was pleaded by both sides. And that is why, my lord, it is therefore elevated to the status of an adjudicated fact.
Yeah.
This, my lord, this is my respectful submission.
Thank you. Thank you. Who else is going to argue? Thank you.
My lords, can I just give the paragraph numbers and then, my lord, or if your lordships have already noted the relevant paragraphs in
Of
Nagaraj.
Yep.
Your lordships have noted.
Number of times.
3 to 56.
That's how many questions.
43 also. 43 also.
Yes, yes.
You have to read,
Yes.
you have to read each and every.
My lord, the behavior of the bulls and not, my lord, your lordship
Everything is
will be
there.
reading it anyway. My lord, let me not restrict your lordship's appraisal of Nagaraj only to certain paragraphs. Your lordships have considered it.
Thank you.
My lord, I'm deeply grateful. Lord, I hope I did not test your lordship's patience.
Oh, in fact, so now we'll have who's arguing.
Very well. Grateful to you.
You are for Mr. Blower?
Lord, I am not that judgment that China, that's in paragraph 11 of the 19.
Yes.
Lordships were referring to that.
I didn't remember.
Para 11 of the same judgment, Professor.
Okay, so I guessed correct.
This is how we remember judgment.
Lord, I for three writ petitioners, Lord, and the name of the organization is called FIAPO, Federation of Indian.
That's all right. What is the number of the petition?
The numbers are 27 of 2016, 6 of 2018,
Yeah.
and 10 of 2018. Each one of them will indicate
6 or 18.
600.
each one of them individually challenge E3 laws. But I'm going to on slightly different points. Mr. Shandiva did an excellent presentation, but he actually consciously gave up the issue of animal rights and whether they are amenable to protection under 21. Well, I'm not going to argue the extreme position that they are covered as persons within the meaning of Article 21. There are lots of questions that have actually fallen from the bench. I like them to answer them. So the first point will be, if I may say so, the notion of dignity in Article 21, which Nagaraja actually places a very, very important place for animals. Lord, may I just say this, Lord? Nagaraja is a judgment of seminal importance because it elevates the rights of animals from your property. Lord, I want, if your lordships will, Lord, this is because I don't want your lordships to hold that portion of Nagaraja, which Mr. Shamdivan rightly, because he didn't want to argue that. It's like a batsman saying, I'll score 6 instead of 4, not because he doesn't agree with it. But I want to emphasize that dignity in Nagaraja is akin to what Francis Corali Mulin did in embarking on dignity in everyone. Let me just emphasize why. But prior to Francis Corali Mulin, of course, your lordships have already noticed from R.C. Cooper, Menka Gandhi, how 1914 actually changed from just the procedure established by law to fair, just and reasonable substantive law. That's important. But what this did, Lord, it's very important to appreciate what Francis Corali Mulin did, because 21 is a classical negative covenant on the state. Please appreciate this.
Yeah.
It's essentially what is known in international law as civil and political right. This is an addition on what is called the theory of progressive realization and non-retrogression. Classically, under international law, after the Universal Declaration of Human Rights, there is a division, partly because of political reasons, between the International Covenant on Civil and Political Rights, which are replicated in our Chapter 3, in our Constitution, Fundamental Rights, and the Economic, Social and Cultural Rights Covenant, which are actually reflected in the Directive Principles. Both are borrowed from the UDHR. Now, 21 is a classical negative right. What did Francis Corali Mulin do? I'm very short.
Over one thing, whose right you are talking about here?
I'm talking about animals' right. I told you, Lordship, I'll answer that. I'm conscious of what my Lord Justice Kumar, your Lordships, my Lord Justice Rishikesh Roy, all the 5 judges have put this question, so I'm going to answer that in a short summary manner, Lord, because your Lordships have limited us in time. I'm going to argue that 21 is invocable. Not through the conduit, as Mr. Shamdivan said, through the injury to the person, human being. Because nomenclature-wise, animals include human beings. We are not talking about biological definition, we are talking about a legal definition, what is possible. But let me just not emphasize this, because let us not lose the sight of the fact that Nagaraja actually made a change towards the betterment. And why, Lord? And I'm giving an example of Francis Corali Mulin because it also changed the whole notion of fundamental rights. Because prior to Francis Corali Mulin, 21 was a purely negative covenant procedure established by law. Life and liberty cannot be taken away. After that, what happened? Moment dignity was introduced. See the power of dignity, beloved. Dignity is an elusive concept, but it is everywhere. It's everywhere. And it actually is the underlying notion of everything, of every right. Not only fundamental right. Respect, autonomy is underlying notion of all fundamentals and human rights. But it is not defined. It is not doesn't have a specific mention. After Francis Corali Mulin, because we introduced dignity, what happened was, and in that case it was access to literature, etc. What happened was, your lordships, in your lordship jurisdiction, under 32, on 36, etc., conferred a positive right. Positive right of what? Right to food, right to environment, etc. It was unheard of, that sort of interpretation. So please appreciate one thing. When we interpret any provision of the Constitution, it has to be expansive, liberal, and it actually fundamentally changes the notion of what happens. That is also what Nagaraja did. When it introduced dignity, what did it do, Lord? It didn't say, and my Lord Justice Radhakrishnan has been very careful in actually trying to balance the rights of human beings, and my Lord Justice Joseph said, rightly, that the scheme of the PC Act and what Justice Radhakrishnan notes is, in fact, the relationship between humans, animals, and environment. And that is continuously evolving. Now, let me give another example. I want to emphasize this. When the Portuguese invaded Latin America, there was a debate in Portugal. They were treated as slaves. They had a high culture, better than Portugal, but they were treated as slaves. There was a debate in the Portuguese, of course, in Portugal and basically in the church. Are these Native Americans, as we call them now, entitled to be treated as human beings? And there was a particular priest who worked with Native Americans. He said they're entitled to be human beings and they have some rights. The other side said no, they are like animals, they have no rights, therefore they can be slaves. Bartholomew de las Casas argued that no, they are incipient human beings. They are like children. What I'm trying to tell you, Lordship, is after that, slavery was abolished. Things changed. Our notion of human beings has changed over centuries. Our notion of animals are changing over a period of time. So this is actually an evolutionary process where things are changing. Let's not be fixed in time space and assume that the rights that were actually accorded to animals will continue to be there for the rest of time. So today, my Lord, we know certain things about animals. As Mr. Shandivan has pointed out, they are sentient human beings. They can feel emotion. They can feel pain. They can feel heat. Therefore, they are similar to us and they have a place in nature. In the place in nature is crucial to us as human beings. Their place in the environment and consequently the role they play in the environment for human beings is crucial for the survival of the human race. Is that pedestal, your Lordship, will look at it, not in the pedestal of just Jallikattu. When we talk of animal rights are no longer in the species of property of human beings. That's the point of departure. So my point is, first, that the Lordships look at this case, not an ordinary case. It's a case in the course of evolution of how we treat animals in the constitutional scheme of things. Now, Lord, I want to read a few passages from Nagaraja. I won't take, my Lord, Mrs. Joseph has put a guillotine and I appreciate that, Lord. I wish only, Lord, my only wish is this, Lord. When the matter starts, the Lordship put a time guillotine to an end. Otherwise, Lord, what happens is, I tell you, Lordship, very candidly, at the bar, there is a jostling for number 1 position, number 2, and number 5 or 6 don't have time. I'm not blaming anybody, but I wish your Lordship will actually say everybody is going to get an hour. And then, of course, your Lordships have the discretion to say, no, we want to hear, because your Lordships are querying.
All that we are saying is that, it need not be repetition.
I want.
What
Absolutely. Absolutely. If there's one word of repetition, the Lordship will give us the
you can definitely say. Otherwise, just say you have to adopt it.
I agree with you. I agree with your Lordship. That's why not a word of repetition from my side. Where I am actually following the arguments and I actually adopt the arguments of Mr. Shamdevan, Mr. Rutra and Mr. Girimilot. But I wanted to just say I wanted to point out passages from Nagaraja, if you lordships will allow me, and I won't read some of them because those they have not been read and I won't waste your lordship's time. Please come to Lord, para 61 of all the other passages have been read. I'm not going to read any of them, and I'm not going to read even the ones I'm relying on, just allude to them. Para 61. When we look at the rights of animals from the national and international perspective, what emerges is that every species has an inherent right to live. Now, this is a very important statement, Manoj. Otherwise, if they were just properties, they would not have the right to live and shall be protected by law. Now, please note the next. Subject to the exceptions provided out of necessity. Necessity is one of the doctrines which the court has adopted. So they are not entitled to full rights. Animals also have the honor and dignity which cannot be arbitrarily deprived of. And the rights and privacy have to be respected and protected from unlawful crime. This is, in summary, what my Lord Justice Radhakrishnan, in a seminal judgment, put forward as an advancement of the rights of animals. Then, there is this declaration of animal welfare. I'm not going to read it, but your lordships have noted in 64, it has been read, the 5 freedoms. My only point I want to make, my Lord, is that, again, in the context of our constitutional jurisprudence, dignity is an underlying concept. Please appreciate that. So, all the 5 freedoms.
Mr. Grover,
My Lord.
last sentence of paragraph 61.
My Lord.
Animals has also honor and dignity which cannot be arbitrarily deprived of and have to be respected and protected from unlawful attacks. Now, can it be projected that what is being done there is an unlawful attack?
In Jallikattu.
That's right.
But may I answer that later on because this is a very important point.
You go ahead.
I'm glad your lordship has raised it.
Just flagged it.
Yeah, I'll flag it, just put it down there. I don't forget. But I will, because I'm developing my argument, I hope in the course of that it will be answered by implication, but I'll also explicitly answer that. Now, please come to 64. What I'm pointing out, I'm not reading out the 5 freedoms. They are based on the underlying concept of dignity. So, freedom from hunger and thirst, all these and more are based on that. Then, please note, what my Lord Justice Radhakrishnan does is he says that look, though we have a statute, the statute actually is in sync with this notion. Para 66. Right guaranteed to the animal under 311, who are only statutory rights, the same have to be elevated to the status of fundamental rights. This is a wish, Milan. I'm not saying this is a law, as have been done by few countries around the world, so as to secure their honor and dignity. Honor and dignity of animals is actually the underlying theme. That is very important. Rights and freedoms guaranteed to the animals under 311 have to be read along with 51AGH of the Constitution, which is the Magna Carta. Now, therefore, you read PCAA and 11 and 3 in sync and under fundamental rights, under directive principles. Then your lordship has seen that compassion is one aspect, humanism is the other aspect in 68, and speciesism. Now, this is important because how animal rights welfare has evolved is important. Speciesism is a concept coined by Richard Ryder in various works on the attitude to animals, like so and so, etc., etc. Defines the term of the assumption of human superiority over other creatures, leading to the exploitation of animals. So the classical view is, like it was even in Latin America, that we exploit others for our benefit. That was the view. Things are changing because we have seen how degradation, treating animals in this manner, degradation of the environment, is actually inimical to the human race. So things are evolving. We have to build new concepts. So my lords, I would request your lordship to see that in that view, in an evolutionary view. Speciesism is also described as the widespread discrimination that is practiced by man against other species. That is a prejudice or attitude of bias towards the interests of members of one species and against those members. Speciesism as a concept used to be compared with racism and sexism on the ground that those refer to discrimination tend to promote or encourage domination and exploitation of members of one group by the other. So the analogy is you exploit black people, Native American, gender, etc., and that is analogical to animals. These things have changed. Why not this? And this is more important because ultimately we have to live together. Human beings, animals, and the environment and the forest are one unison whole. That's the point. Then your lordship will come. One school of thought is that casteism, racism, and sexism are biological classifications since they are concerned with the physical characteristics such as discrimination on the ground of caste, creed, religion, color of skin, reproductive role rather than with physical properties such as capacity for being armed. But I don't know if your lordship remembers, in the early part of the last century, there were psychologists and psychiatrists who actually propounded theories, Jensen, etc. They measured the skull of Africans and they argued that white men are mentally superior than black. And they were trying to use this is a huge thing till the 60s, till I was in university in the 70s. That was being propounded. And it was the underlying basis of Nazism. So what the analogy is very apt. That how you treat your other human beings because of various factors, because you have better facilities in terms of travel, weaponry, etc., and you dominated other communities, then you try to argue that other communities are in fact inferior. Similar analogical theories were propounded for animals, and that is undergoing evolution. Now come to 70 million. We have gone over those inequalities like casteism, racism, sexism, etc., through constitutional and statutory amendments like Article 14 to 78, etc., etc. So far as animals are concerned, Section 3 of the Act confers rights on animals and also rights under Section 11 not to be subjected to cruelty. Now, the first answer is, therefore, animals have statutory rights. There is no question about it. The PC Act itself says that there are rights. So there are statutory rights. I'm going to develop this argument further to say they have rights which are based on dignity, which are constitutional rights. Let me develop it.
We are waiting for development now.
I'm sorry, Lord.
Not development. Judgment has been gone through.
No, this has not been argued at all. Please, let me.
Robert, make your submission straight away.
I will. Just let me read one paragraph. One paragraph, which has not been read to your lordship.
Robert, we can't go from the paragraph 1 to the last paragraph. You make your submission straight away.
I'm going to argue that what is in Nagaraja is to be preserved. And I want to allude your lordship to that. Just give me 2 minutes. But I'm not repeating, but once your lordship has said this, I'm not going to read paragraph. But I only read paragraph 71 and 70. 71 and 70, your lordship. We have, however, a lot of, why I'm saying this is slightly different. There are what are called non-essential activities. That's what I want to point out, because when your lordship will balance Jallikattu, the right of so-called cultural rights, which I don't think exists, I'm not going to argue that extensively, and the dignity of animals. If unnecessary pain is being foisted upon them, then your lordship will actually hold in favor of animals. So the balancing is important.
I've understood that one.
Very well. I will not read them.
That is why the other question was also put avoidable, because it is
Yes, your lordship is right.
paragraph 71 is there. It is realizing that that question was put.
Correct.
Not as if we are not.
No, I know. In fact, I noted what my Lord Justice Kumar said. But then only let me read 72. Only 72.
Gives a dignity, not essential. We have noted.
Yeah, right to life. Now, this is the crucial paragraph. Let me read just 72 and we'll stop at Nagaraj.
Why don't you develop it without reference to just give us a
So
paragraph
I want to.
and tell us we can.
Very well. Your Lordship.
Otherwise, it will not be over.
No, it'll be over. I will be.
Not today. I mean, we are talking about others. We intend to complete the petitioner side for Maharashtra, Karnataka. You must realize that also.
No, I appreciate. Look, that's why I said at the outset. So, my respectful submission is 72 actually mentions
All right.
what the right to life is.
Para 72 cents.
Yeah.
You
So,
don't have to read it, yes.
Lord, now, I'm developing my argument. A horse, Nagaraja. Okay. And Mr. Shamdevan mentioned it, but he stopped at a particular point. I'm not saying animals have the same rights as human beings. This is evolving, and over a period of time, animal rights are actually increasing because we realize that they are necessary for our own survival in the environment, the role they play. Now, their right to dignity is till they are alive. Let me say that as an example. Because my Lord Justice Joseph is putting this point repeatedly. Killing to eat is the most cruel form of cruelty. Correct. Like putting a person to death after death penalty has been meted out to that person is also cruel. We accept it. But we say that for human beings, they are entitled to dignity throughout their life, and for human beings, even after their life. They are entitled to decent burial because of Article 21 and cultural and religious things under 25 and 29. As far as animals are concerned, this is a point of departure and difference. They are entitled to dignity of a particular type which will come to till they are alive, but not after they are dead. So the law, because of our understanding and our relationship with animals as it is evolving, posits that we will treat them with dignity, but killing them either for food or for experimental purposes or certain exceptions, they will be killed. So that is the relationship in terms of superiority. Now, therefore, the balancing of rights is an important exercise. There the doctrine of necessity comes in. Is it necessary for us to do certain things? Or, like for example, experimentation. It's an exception. Now, let me also tell you, Lordships, that in terms of drug trials are carried on under pre-phase 1, phase 1, phase 2, phase 3. In the pre-phase 1, animal toxicity studies are done. That's the norm. We expend animals for the purposes of our betterment. This is changing now. For example, we don't do dissection anymore on a physical animal. We have technologies which allow that to be done without actually touching an animal. But phase 1, phase 2, phase 3, phase 4 trials are on human beings. It's not as if there are no experiments on human beings. I just wanted to point that out. In fact, the Drugs and Cosmetics and Schedule Y make it very clear that until drug trials are carried on human beings, no drug can be approved. So just that there is an exception doesn't make animal a subordinate person. Now, what sort of rights are the animals entitled to based on the dignity that is bestowed to them? I hope I'm clear that the right to dignity is vested in animals, but it's a different type of right. It's not the dignity that we afford to human beings. What is the meaning of dignity? I teach. So the students ask, what do you mean by dignity? It could be, for example, I'm arguing. I'm just using myself as and your lordships are looking at it. No, lordships are not this. Not that lordships are not this. Suppose your lordships are not listening and ignoring me. I'm treated with this respect. Then your lordship will not be treated with dignity. That's one level. The other level is to say you are a useless person. Third would be to beat up a person. So there's different levels. So what is the first thing is that as far as animals are concerned,
if I know difficulty in making submission, but not on yourself.
Very well, that is, I'm getting somewhere. I'm getting somewhere.
Full attention is on you.
No. I hope it's the judge's attention, Lord. And not other people. This is very important, but I'm afraid of these things. I don't know how your lordship treat this, but this is not the.
I think the same reflection there.
No. I am in case, Lord, I mean, we are actually subject to now the whole world as an audience and the whole world to criticize us. Now, so, Lord, what is the level of dignity that the animals will be entitled to? First of all, they are not treated as property. So, I'm going to call out things which are different. Then they are entitled to those 5 freedoms because of dignity. I'm just giving examples, Lord, which your lordship.
Now, Mr. Grover, so far we accept your proposition that Article 21 person are interlinked with the environment and animal.
Minus.
But from there, where do you take
No.
the
The next proposition, Lord.
Jallikattu is concerned?
Welcome. Because Lord, if I had said to you, Lord, let me be very candid. Lord, this arguments are Mr. Sibal knows better than me. There's also a psychological issue, Lord. When we put an extreme proposition, the Lordship is rejected, I won't be able to argue anything else. I've learned it from Mr.
I know better than because I always put extreme propositions. That's my learned friend suggestion.
No, you taught me not to put extreme propositions. So, right, my learned friend is a great teacher, Lord.
Jallikattu is concerned.
So, Lord, I want to put it quickly. This is unnecessary pain.
Only thing is, these are not voluntary action on the part of the animals. They are compelled to do it.
Yeah.
That is one.
One, wait.
Two, what is?
No, Lord, why? Because my Lord Justice Ravi Kumar asked on the first day. They have no agency. They are not voluntary because there is no question of volition on part of animals. If they're in their own environment, like for example, the construct of willingness in human beings in law is one, consent is the other. There is no question of those constructs coming in the case of animals.
Now, the law also permits using the animals for human need.
Yes, that's an exception.
They are compelled to do involuntary acts for the benefit of humans.
Correct.
So we want to segregate the nature of benefit, that not the entertainment benefit, but physical benefit. This is what you.
I'm not doing it now. Both Nagaraja and the PCF does it. PCF to a certain extent.
Yes.
That is exactly what I was trying to read in Nagaraja. This balancing exercise is by the invocation of the doctrine of necessity on the one hand and exceptions on the other. That's the balancing act.
In Nagaraja, the most important one, you read paragraph 71, but not
I didn't read it.
the last sentence.
No, my
Last sentence in paragraph 71 is very crucial.
I'll read. May I read that?
It says both anxiety and fear.
Sorry, Lord.
It says, it reads this, like this. Both anxiety and fear therefore play an important role in animal suffering, which is part and parcel of the human cycle.
Correct. I agree. I wanted to read that, but to deference to my lords, I didn't read it. So time. So what I'm saying is the overall.
So here our question is, why should it not be left to the lawmakers?
No.
And why should we take ourselves the duty of deciding to what extent we shall extend the.
No, there's no question of
necessary or not necessary. All these are all
No,
balancing factors.
May I answer that? The law has balanced. Now there is an introduction of an amendment.
But still, that's also law.
No, I'm not disputing that. Of course, I can't dispute it. What I'm saying is that not only your lordships have noted, completely nullifies the parent act. Nullifies the parent act, but your lordships have to interpret whether in the context of balancing of exercise, is it unnecessary? Is it an exception under the law? Those are the things that your lordships have to look into.
So do you decide what is unnecessary?
Your lordships have, because the unnecessary thing is not defined. It's what unnecessary pain is caused. Is it necessary to cause pain to the the bulls, because of Jallikattu, because of an imagined culture, etc., or does the balance go on the other way? If it is not an exception under the law, if it is not necessary under the doctrine of necessity, you will hold it up.
Now,
That is it. I'm sorry.
That we have already made out, that it's not necessary, we have noted it twice.
No, I'm answering the question.
Yeah, since you have said, you have noted it, you move on to the next point. Otherwise, what will happen? You have taken it down, dignity. It is not essential. It is not covered by any of the essential means.
No, my Lord Justice Ravi Kumar asked me to read a portion.
I already said you stopped it there. First part of 71 you have actually brought to a notice. The last part did not.
Both are important. Both are important. Look, my Lord Justice Joseph. Have to be international to all judges. I can't be
Eagerly waiting for you.
Now my next point is, your lordships are aware that Qureshi, etc., directive principles and fundamental rights are being consonants harmoniously. So 51A G
Yeah.
is an important part. So when you're talking of dignity, the question will be, if your lordships accept that animals have the right to dignity, then where is it situated? Is it in 51 AG? I would say that it is situated in 21. Because that your lordships have already had. So 51 AG read with dignity have to be actually read into 21. So that is the next point.
To be read into 21.
Yes, 15 AG read into 21 is not a problem. But dignity according to human beings in 51 AG will have to be read into 21. That's the point. Therefore, my lord, the next point developing on that is that Article 21, right to life, can be only realized for animals if 51 AG is complied with.
Yeah.
Therefore, compassion, etc. I've already argued with necessity and reasonable. Now, my lord, the last point, which is more difficult for me, which your lordships are waiting for me to. Now, my lord, your lordships are fully aware. Let me just develop it in a minute. Lord. It is protection against life and liberty except by procedure established. Just consider, my lord, for a moment. Today, don't we have all laws to decide how animals are to be slaughtered? So, the horse, the development of 21 before Maneka Gandhi, or even say R.C. Cooper, it was only procedure establishment and not substantive. Today, there is already a plethora of legislations which actually indicate how you can extinguish life of animals. So, my point is that it can be argued reasonably that you cannot deprive a right of life of an animal without procedure establishment, not substantive. I'm not on that right now. Only procedure. Even now it is there.
You're contending that the animal is a person?
No. Therefore, that is the. It's not easy to say it immediately. Let me put it that way. Because when we decide, I was thinking this is because it's troubling your lordship, it's troubling me also. I can't be. I have to be candid to your lordship. This is not a all animals are entitled to all human rights in 21. No, I'm not saying that. I've already scaled it up. Therefore, one is what Mr. Diwan said, that it is correlated to the human beings. I'm not on that. I'm saying that when you deal with animals, first they have to be respected, they have to be accorded dignity, and when their life and liberty are at stake, that dignity must come in. And I can only situate it under 21. But I'm not saying that everything under 21, which is according to human beings in our constitutional jurisprudence, will be according to animals. I'm not saying that. But I have to be honest with your lordship, I'm struggling on that.
So are you still saying that the animal is a person? We are again asking you.
Yes, I'm saying that at one stage we'll have to say that. That depends on the evolution of various technological developments.
Today, as on today, do we have
I'll say partially, yes. I will
enough
say.
material to declare that?
Animal. Yes.
I'm saying you can, your lordships, in a specific sense, say that animals are entitled to dignity and life and liberty under 21, but scaled down. That's your lordship's interpretation. I'm saying that it should be accorded that.
All right. We have understood you. Yes.
Very good. No, your lordship is understood. I'm not going to. So,
Collateral to 21.
I'm sorry.
Collateral to 21.
Yeah, collateral. Because, please remember,
Fine.
even dignity, even privacy in the Puttaswamy case, when we were arguing it, there was a genuine difficulty among judges and lawyers. How do we situate it? And I remember Justice Nadu said, but it can be 19, it can be 21, it can be 14. How do you know it's 21? So it's not an easy task. But I am telling you also candidly, I am saying that your lordships, after Justice Radhakrishnan judgment, will not go back. I won't polish down retrogression, but not add a lordship on that. The theory of progressive realization, doctrine of progressive realization, is actually applicable to what are called economic, social, and political rights, as opposed to civil and political rights. Civil and political rights are directly enforceable. As far as the economic, social, they are progressively realizable. As they are realized, you can't go back. That's the only caveat I wanted to add to Mr. Diwan's argument. Now, that's my argument on 21. So I'm stopping it. The second point, I want to argue this. The lordship has already seen in terms of the conflict. I'm not getting into that. I want to argue that there is no assent by the president in the manner known to law. And for that, I thought we had proper pleadings, but I must be candid again to lordship. One sentence. We have the draft person has actually put all the points in law, but not said that in this case there is no assent. So I have, with your permission, just added that line as an amendment to the petition. I have to be candid, your lordships. I can't, because this is a constitutional case, I don't want.
But tell us
Why tell your lordship?
what is
The law is very clear. The law is that any consent, assent by the president, has to be informed. If it is informed, you have to tell the president by letter or document that there is a conflict between the state law and the central law. That is, according to us, we reasonably believe it is not done. If it is not done, it is no assent in law. Simple. And there are two known, Mr. Luther has already said it. So not.
But one should presume the presumption in evidence law is that
It is regular. 114 acts are regularly performed. So Mr. Trivedi was, no, you have not contended it. It is contended except the last line that in this case is not contended. So I've taken an amendment out, not one line only. And also I've asked them to produce the documents last week. Produce the documents, show. That's the end of the matter. I don't want anything else. So that's one word. Judgments, lordships go on that. Just give the two judgments. But I'm not going to read them all. When their turn comes, let them produce. But without production, your lordships will not be satisfied. Well, let me labor on this for a minute, Lord.
So you just give one decision which you want to try on in this. Yes. Just one. You don't have to multiply.
Yeah, just, yeah.
Any one which. Any one judgment, please.
Case and a Hind, lordship knows.
Just one case, Lord.
Case and a Hind, Lord.
Just one case. I don't need.
Yes, Lord. 2002 8 SCC 182. Case and a Hind, the lordship knows. I'll just get the lordship the paragraph.
2008.
2008 8 SCC 182, Lord.
2008.
Presentation assessed has to be informed.
What's 18?
Page.
182 Act, paras 3, 11, 14, 16 and 20.
All right, we'll see that.
So there's another decision, I'll just cite it. I'm not going to read it. It's very well. It's followed in Ravinder Singh,
Okay.
Gram Pachan.
What is the next point?
Now, the next point is that it is according to them cultural practice.
Yeah.
They had argued at the review stage that it is religious practice. That was given up and it was ruled against them. Now, they will come up. They should be candid with the court. You can't one time say it's religious practice and the second time change your stance and say, no, it's not religious anymore, it's cultural. They have to be very clear. And 25 and 29 are very separate. You know, that is one. They have to affirmatively establish, because they are saying as part of cultural practice, and 29 your lordships are very familiar. Sections of citizens having, I'm not reading it. And then they say that it is to promote native race. Now, my point is they have to affirmatively establish it. One. They have to affirmatively establish it. And actually, they can't. Once they plead it's a religious practice, now they shift and they say, no, it's cultural practice. Now, that's one. Secondly, even otherwise, 29 and 29, 21, all the fundamental rights have to be read harmoniously. So even let's assume that there is a cultural practice. Can it lead to the denudation or derogation of the rights in 21 with dignity of animals? It cannot, because the law is very clear on that. That just take an example of sati. There is a cultural practice of sati.
Somebody, that portion is read out to us.
Yes.
We cannot have it contrary to.
Correct. Yes. There only one judgment on that. A portion of the cultural practices which otherwise violates another fundamental right will not survive. That's the point. I'm not putting it quickly. Just give the judgment.
What's your next point? Anything else?
No.
Not on that. AR 2000 SC 2773, para 30.
Yes, what is the point?
Not that they have to be harmoniously construed the fundamental. I've already argued that, so I'm just writing the judgment. I'm not, secondly, 2 more.
Yeah.
1 point won't take long, another point may take a slight time.
Yeah.
Lord, in any event, if your lordships agree with us, on the ground that Mr. Shantivan argued, Mr. Luthra argued, Mr. Giri argued, they host my submissions. If the statute is held to be ultra-virus, that's one thing. But a statute always overrides custom. That's the law. So that will not on that. Just give me that.
Overrides custom.
Yeah. Not common law, customary law. This is the state said. Now, the final point is on the issue of rules, which is troubling me and troubling the lordship also.
Grover, give the citation on the.
I'm going to give 1 minute. Give me the I'll just give it.
Yeah, sure.
I'll meet
Last argument is on.
last argument. No, I am going to stick to my promise. I am not. I insist.
Rules.
Yes. Let me see the parent acts. it's very important to appreciate the actual rub lies in first amending the act. I'm not reading the sections. And then saying nothing of the cruelty will apply to us. Now, if it is a genuine bona fide and I'm not on the culpable legislation. If it was really to prevent cruelty, then they would not say that none of the provisions of 11 apply. The rub is in this, that none of 11 applies. Why? I asked myself this question. Why? Because they know fully well that 11 will apply. Otherwise, why should we do it? We have to see, we have to assume that there is a purpose in 11 being amended. And 11 is being amended because they don't want 11 to apply. And that is the whole part of cruelty. And then they substitute that by mechanisms, only mechanisms which actually are to ensure, but not the core of it. The core is what is specified in section 11. But that is taken away. Then how do we prevent cruelty? We can't even have it by a mechanism. So that's the point I'm making. It's not, I'm not on tolerable. Tolerable is, and the Lordship has already said, if entry 17 is being used, and they say, no, it's not 17, but it's actually 14 and 15 of list 2, then it will be colorable. That's what they're doing. I'm not re-arguing on colorable. But here what is happening is, they have taken away all the safe haven. Sorry, they have taken all the action that the government can take on cruelty under section 11 and created a safe haven to perpetuate cruelty, to perpetrate cruelty. That is why it is clear that the purpose is not to actually do a breeding of native breeds of culture, but to actually escape from the liability on the Prevention of Cruelty Act with cruelty. Now, what they say, only last one, native breeds. Because this is concerned with native breeds. Now, we have come up with reports post Nagaraja. No. They are slim buffaloes. Their size is this, they have this and that. That's a new fashion. But please appreciate that kind of evidence is not taken into account because this is vested on evidence which is biased. Because you created it for this purpose. Evidence which was the horse knowing of this is important. And Tamil Nadu has its own reports on this, which I want to just point out and then stop. Now, let's see in my compilation, just give the reports. Not compilation, I don't want to bother you. Is it in the compilation? In the convenience compilation by Mr. Justice, by the Mr. Luthra, by us, not in the convenience compilation, we have put a report of Tamil Nadu, which is document 33, volume. But I want to just not read out, just point out the portion which is very important because the sum and substance is this. And I'll stop with that because if your Lordship will allow me to file written submissions later, but I don't want to.
That you can do.
Yeah, only one point I'm going to make. Just keep document 33, my lord. Page number 436, it starts. Minutes of the Department of Genetic and Breeding of Tamil Nadu, and they talk of breeds. This will take only 2-3 minutes. Not what is it? Yeah, I'm not reading it. I'm not. Those portion they're at 444, 444, 445, 449, and 524. Now, they specifically refer to the breed or species Jallikattu, which are used for Jallikattu. Specifically, their argument is that in order to preserve the species, Jallikattu is necessary. Now, in this, an independent report not taking into account the litigation, there is not a word of Jallikattu to be used to perpetuate or preserve or conserve these species at all. as well as all other reports which are elsewhere in the convenience compilation. What they say is, why are native species dying? Last one. They are dying because these were draft animals. They were draft animals used to carry goods in the agricultural work. These agriculture work is now replaced by tractors. Therefore, they are not needed anymore. That is the reason of the native species dying. It's got nothing to do with Jallikattu. Therefore, my lords, I'll stop here because your lordships have put me on guilt.
Thank you.
Citation, my lord, that citation, my lord, Justice Roy wanted. This is Nimasha versus Janabi, 2006, 13 SCC. First term is over, it is my statute. 2006, 13 SCC, 627. Lord, only, my lord, I'm so sorry. What do you know?
Yes, who is next?
Lord, much obliged.
Thank you. Thank you. Who else is there? We take it that Tamil Nadu side is over, going to Maharashtra.
I'm Tamil.
So you are okay.
My apologies.
You take it the other.
I am in the very
You are on 97.
No, Millets. Let me just explain my proposition. But I'm on the proposition there's no legislative competence for this law. That's one.
You are which?
Writ petition.
The first writ petition in the list, Millets, today, 23 of 2016. I'm for the second petitioner, Ms. Anjali Sharma. And my learned friend wanted to point out that he is also there after me, Millets.
As far as I am concerned, my lord, I do not represent the Tamil Nadu matter at all. My lord, I am really not concerned with Jallikattu.
That's it. So
I am concerned with Maharashtra, which is entirely different.
that's it. Let them
Voices are different. So I am waiting that if Tamil Nadu is over, they will have to.
That's right. So he's the last person we are going to permit him from Tamil Nadu. We have had enough from Tamil Nadu. we have had spent enough time.
I bow down, Millets, I understand.
So in your case also, you will limit your this time.
I'm going to try, Millets, to limit myself.
What we are going to do is,
I'm only going to make arguments that your lordships have not heard till now.
He is the second, representing the second petitioner.
petitioner in a petition which is already argued.
It's not been argued, Millets.
You argued it for the first petitioner.
Nobody argued.
What is your?
Because they are not now willing to join.
Oh.
Animal Welfare Board of India has backed out.
Oh,
Which should tell your lordship something about what is involved in this matter as my respectful submission. That is after having been the Millets
What is the number? Kindly give us, please.
writ petition 23 of 2016. I am for the second petitioner, Anjali Sharma,
No,
who is a former member.
They are not prosecuting.
first petitioner is concerned, the petition, they are not pressing it.
They are not pressing it, Millets. I'm correct on that.
Yes, go ahead.
In this verification, we have also filed for intervention.
We consider hearing you, let us see, if it is necessary, we'll hear you.
Either I.
Yes, go ahead. So I'm going to say from 4 to 3, we are going to see. Whatever we are going to see next one. Whatever.
This is even the point.
Yes. I am going to be making two main submissions. First is, there is no legislative competence
No legislative competence.
to pass this amendment at all.
Yes.
To the extent under this to the extent that it is. First, I told your lordship, there's no legislative competence. Under that, I wanted to submit that A, to the extent that this law cannot be traced to entry 17 of list 3. Yes. To the extent that it cannot be traced to entry 17 of list 3 or to any other entry in list 3, presidential assent is immaterial and cannot save this Amendment Act. First proposition. Second proposition is it cannot be traced also to entry 15, either 14 or 15 of list 2.
14 or 15 of list 2.
Yes. And therefore, for these two reasons, there is no legislative competence.
Not point.
Yes. And consequently, at best, it can fall under list 1's residuary entry, as fell from my lord the other day, and no other. Whether Parliament, my lords, your lordships had asked the question, whether Parliament, whether Parliament will pass the amendment or not, I don't know.
Yes.
But at that stage, we look at the parliamentary amendment, is my respectful submission. Now, my lords, let me explain why I say it cannot be traced to entry 17 of list 3.
Yes.
My lords, when the original law was passed in 2009, the Tamil Nadu Regulation of Jallikattu Act, it could have been argued that because it sought to regulate Jallikattu, which may cause cruelty to animals, therefore it's a law which is traceable to prevention of cruelty to animals.
Correct.
But the moment Justice Radhakrishnan, His Lordship Justice Radhakrishnan, renders a finding of fact that it is necessarily cruel to the bull to make it engage in this particular form of exhibition, performance, sport, whatever you call it. The moment this finding was rendered, any law which now seeks, my lords, to allow Jallikattu, to permit Jallikattu by allegedly making it more palatable, by making it less cruel, whatever you call it, is no longer traceable to this entry. The entry is not, and this is my respectful submission, the entry is not cruelty to animals. The entry is not performance, exhibitions, etc. of animals or competitions involving animals and or humans. The entry is prevention of cruelty to animals in entry 17 of list 3.
Yes.
Therefore, by definition, my lords, in my respectful submission, the pith and substance of this act and the rules, assuming that the rules are grandfathered into the act about which there is some, my lords, lifted into the act, in my respectful submission, this can never in pith and substance be relatable to entry 17 of list 3. Then, my lords, the next limb is that the entry 14 and 15, when one looks at the pith and substance, it is not related to agriculture, animal husbandry, etc. It is not related to protection, preservation, improvement of stock, or veterinary practices, or whatever.
So, Venugopal, see, isn't it not better that now you have ticked it off? Basically, you have flagged the issue. depending on how they are going to defend it. You can elaborate it at that stage. Why we are saying it, now they have to meet it. We have argued it. So we call upon them to meet it.
Unless
you want to.
I do want to substantiate it, Manoj. I want to cite a couple of cases, show your lordships how the act has to be analysed, how it has to be treated, so that he can meet it in full, Manoj.
You can just give the citation so that.
No, I want to just analyse it for my lord so that your lordships see that what I'm saying, that in pith and substance, it's not a law which is relatable to these two entries, is made out.
According to you, the entry would have been perpetration of cruelty to animals.
Well, that is what His Lordship Justice Nariman has framed as the first question. If your Lordship kindly sees the questions, my lords, that were framed for placing before my learned friend Mr. Vivedi had said that nobody has argued lack of legislative competence. I'm afraid that may not be correct. He may not have read my amended writ, is my respectful submission. We have raised these issues squarely, my lords, in our grounds. So, if your Lordship sees the reference, the very first question is the Tamil Nadu Amendment Act referable in pith and substance to entry 17 list 3 of the 7th schedule to the Constitution of India, or does it further and perpetuate cruelty to animals? And can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of the concurrent list? So this is squarely framed and before my lords, and I'm going to try to make that case good. And I won't take very long, my lords. I recognize that when your lordships meet in a configuration of 5, that your lordship's time is even more valuable than normal, my lords.
But which are the decisions you want to tell us?
The first decision which I want to cite, my lords, is State of Rajasthan versus G. Chawla,
citation
1959, Supplement 3, SCR 904. I find this decision, my lords, to be 1959 Supplement 3, SCR 904.
Supplementary SCR.
Yeah, 3 SCR.
3 SCR.
I find it to be the most useful to understand, my lords.
Page.
90.
At 908 onwards, but I want to place it, my lords, so that your lordship
908 submission. We would.
State of Rajasthan versus G. Chawla. Because case has to be applied, my lords.
Is it 904 or 908?
904 at 908 is where I want to read it out to your lordships. Just
so we would request you to allow us to go through that. We will undoubtedly go through that.
No, my lords, with respect, my lords.
Otherwise,
I am going to seek an opportunity, my lords, to place my case. I won't take very long, but I have to place my case, my lords.
You have cited the judgment and the point also you have very clearly articulated so that you.
I bow down, my lords, but I am told that in the old days, Mr. Satulvar used to put one hand in his coat pocket, my lords, and state propositions to your lordships in 5 minutes to 10 minutes. And sometimes 15 minutes, and then say that's it and leave. And your lordships would say that's more than enough for Mr. Settleward. But I know Settleward, I need to explain my case and make it out a little bit, my lords. That's my respectful submission. So let me please place these judgments. I need to place one more judgment also, which I'll give the citation.
What is that?
1997 8 SCC 360. State of Bihar versus Indian Aluminium. 1997, Volume 8 SCC 360, State of Bihar versus Indian Aluminium. And then, after that, I will be citing the two judgments, my lords, the cow slaughter judgments. One is Mirzapur Moti Qureshi and the other is Mohammad Hanif Qureshi, the earlier one, to make out only this point that it cannot be traced to entry 15.
Paragraphs of Qureshi.
That, my lords, I'll give my lords tomorrow when we meet.
No, we think what we intend to do is we are going to sit for 1 hour today extra, so that we will cover up because tomorrow we are having constitution bench. We are having the same bench tomorrow, so we think we can devote time today. We are sitting extra 1 hour unless you don't want to sit. I mean, you don't want to.
Let me finish tomorrow, my lords, is my respectful request.
Then let the Maharashtra lawyers start. I mean, and Tamil Nadu. I mean, whoever else is there, you cannot finish it today. I mean, we can only.
No, so then your lords would not hear me at all.
No, we are not saying that. Since you are insisting, we have told you we'll go through your the paragraph, because we have understood your points.
No, you've understood the point, but not, your lordships have not understood the way in which I'm going to articulate that point based on the.
You get an opportunity when the other side replies. That's what you're saying.
No, Mr. Venu, why don't you do it straight? I mean,
Very well, let me place the judgment.
take another 5 minutes or so.
Yes.
Just finish that.
We will take a little time.
No, that's okay. I mean, let's not debate on the time and then.
Yes, your lordships are right. First, my lords, let me just show your lordship the Tamil Nadu Act. Let me show my lords the Tamil Nadu Act.
Yes, sir.
It's not for Mr. Venugopal alone, but for the others also. We intend to conclude the conditional second. That's what we intend to do.
It may be a little difficult, my lords, but let me try. Please see at page 137, my lords. I just want to show your lordships.
You are entitled to take the 2 minutes break, which we may need.
Very well.
We'll just come back up. So you'll also get that,
Very well.
idea.
your lordships take page 137 of the convenience compilation, which I believe Mr. Rupa was relying upon, compiled and filed for Ms. Sri Kumar. 137. It's the Tamil Nadu Act, my lords. So I just wanted to show, my lords, first I will place G. Chawla to show how it is to be done. If your lordships would kindly take up this 59.1 SCR, your lordships may kindly supplement 1 SCR. 59 supplement 1 SCR. Kindly take page 904. Keep 137 with your lordships for a moment. First, let me show this judgment, fellows.
Yeah, tell us.
At 908.
Yeah.
In fact, your lordships may then see at the second paragraph on the page, it becomes therefore necessary to examine closely how the Act is constructed and what it provides. The Act in its preamble expresses the intent as the control of the use of sound amplifiers. First section deals with the title, the extent, the commencement, and the interpretation of the Act. It does not unfold its bit and substance. The last two sections provide for penalty for unauthorized use of sound amplifiers and the power of police officers to arrest without warrant. They stand or fall with the constitutionality or otherwise of the second section, which contains the essence of the legislation. That section prohibits the use in any place, whether public or otherwise, of any sound amplifier except at times and places and subject to such conditions as may be allowed by order in writing either generally or in any class of cases by police officer not below the rank of an inspector. But it excludes the use in a place other than a public space of a sound amplifier, which is a component part of a wireless apparatus duly licensed under any law for the time being in force. In the explanation which is added, public place is defined as a place including a road, street, or way, whether a thoroughfare or not a landed place to which the public are granted access or have a right to resort, over which they have a right to pass. The gist of the prohibition is the use of an external sound amplifier, not a component part of a wireless apparatus, whether in a public place or otherwise, without the sanction in writing of the designated authority and in disregard of the conditions imposed on the use thereof. Does not prohibit the use in a place other than a public place of a sound amplifier, which is a component part of a wireless apparatus. There can be little doubt that the growing nuisance of blaring loudspeakers powered by amplifiers of great output needed control. And the short question is whether this salutary measure can be said to fall within one or more of the entries in the state list. It must be admitted that amplifiers are instruments of broadcasting and even of communication. And in that view of the matter, they fall within entry 31 of the union list. The manufacture or the licensing of amplifiers or the control of their ownership or possession, including regulating the trade in such apparatus, is one matter. The control of the use of legitimately owned and possessed to the detriment of tranquility, health, and comfort of others is quite another. Cannot be said that public health does not demand control of the use of such apparatus by day or by night or in the vicinity of hospitals or schools or offices or habited localities. The power to legislate in relation to public health includes the power to regulate the use of amplifiers as producers of loud voices and the right of such user by the disregard of their comfort, etc., etc.
We have understood you.
Now, please read the next paragraph. The pith and substance of the impugned act is the control of the use of amplifiers in the interest of health and overall tranquility, and thus falls substantially not wholly within the powers conferred to preserve, regulate, and promote them, and does not so fall within the entry of the union list. Even though the amplifier, the use of it, yes. Now, my lords, having said that, if your lordship also sees the next page, my lords, the paragraph in the middle of the page. On a view of the Act as a whole, we think that the substance of the legislation is within the powers conferred by entry number 6 and conceivably entry number 1 of the state list. Does not purport to encroach upon the field of entry 31, though it incidentally touches upon a matter there. Now, my lords, the second judgment I want to cite is State of Bihar versus Indian Aluminium, which is 97-8 SC 16 to 20.
So, if you don't mind, we can read that.
Yes. No, I'll just read the relevant portion then.
We noted they are not going to give it address.
Yes.
And you are asking it noted so that they can reply. That's what I'm trying to tell you.
No, I'm trying to say, my lords. In fact, please correct that to 15 to 20, my lords. 15 to 20.
15 to 20.
So the short point here, let me summarize the point. This purported to be a tax on land under entry 49 of list 2. Now, the court here found that it is actually a tax on the absence of land because it taxes the void. And ultimately, it really boils down to a tax on the use of forest land for non-forest use. So therefore, it was not a tax on land. So the emphasis here was on the use of the land for non-forest. So now please see, my lords, in light, and I'm not going to again take my lords to the paragraphs in Nagaraj, which clearly say bulls are not performing animals, they're not designed for this activity. It is cruel to them to make them run in this manner. They will only run if forced, beaten, whipped, etc. The lordships may recall, I don't know if anybody has placed this, but at the beginning, the lordships have reproduced long excerpts from the reports which show how cruel it is. So I'm going to summarize for your lordships what I understood. Basically, the bulls are not inclined to move from the Vadivasam, which is the holding area, into the ring, bull ring, the arena. So therefore, what they do to them is they poke and prod them. And I believe this has been placed before my lords. And ideally, my lords, in my respectful submission, your lordships do not see a video of exactly how this is done. And we have placed such videos on record. Now, I'm told that they are vociferously and violently objecting on the other side to your lordship seeing a video because they believe that it may influence my lord when your lordship see it. But without your lordship seeing it, sitting at a distance, my lords, in this august chamber, my lords, your lordships don't get a feel of the reality of what the bulls are subjected to. That's my respectful submission. So if your lordships allow one screening on your lordship's TV of a short video of a few minutes to see what is the nature of this, we'll be grateful.
We'll come to it when it's necessary, we will consider.
Unless if your lordship says that
No, not now at this stage. You have made a request, we will note it and we'll see.
Yes, we would like, my lords, your lordships to see that.
That's right.
Because one picture has the weight of 1,000 words.
That's right.
And in this case, possibly
Therefore, what the
3 days. So the suggestion I'm making is how they are moved.
no legislative competence that you have.
No, I'm not now talking only about the dry bones of the law, my lords. I want to tell your lordships what I understood from a reading of those reports. I'll summarize. It will take me a minute.
That's not your point. We thought that has been argued elaborately by.
No, I know. But I'm trying to tell my lords that the reason I'm saying this is because essentially I am saying cruelty is integral. Cruelty to animals is an integral part of this particular sport, performance, exhibition, whatever you call it. To move the animal into the ring, they put chili into their nose, they pour alcohol down their throats and other substances such as cocaine.
We
have got it. We have seen.
Yes. Then they are poked, my lords, with nails, that is sticks studded with nails to make them move. Thereafter, my lords, when the bulls are maddened to the point where they run into the ring. And thereafter, they are wrestled down and made to submit. In pain, they bellow in fear. I, my lords, can tell my lords that in the bullfights in Spain, for example, it is heart-rending. I have not attended a Jallikattu myself, but it is heart-rending to hear the bellows of the bull when it is poked by the spears of the matador. And the way that they are treated, my lords, the fear of the animal, until your lordships realize that the rights that we are speaking of is based on putting ourselves in the place of that animal. And how you would feel if you are tortured, where you don't have an understanding of what you're expected to do, tortured, made to bellow in fear and pain, turning round and round, looking for some way to escape. They go and charge the barricades, which is the effect of the reports that have been placed before my lords, charge the barricades in their, my lords, mad rush to get out of the ring, which causes injuries to spectators as well. Now, the submission I'm making is when all of this is taken into account by the court, and the court renders a finding that this is cruel to animals, inherent and integral to Jallikattu, then, in my respectful submission, there is no further warrant, however much you may cozen and cosset these people cosset these people, that is the Jallikattu fighters, my lords, and the bulls, however much you may make small changes or big changes, if the act remains the same, that you keep them in that arena.
You are
And then,
what has been argued.
no, then,
Telling you,
yes,
heard this argument.
yes. So let me, yes, very well.
What make out your point?
Yes, the simple
points.
the simple point I'm making is, therefore, this essentially amounts to cruelty to animals. You cannot now, and that's the connection to legislative competence, you cannot now carve out an exception to the Parent Act, that is to say, the Prevention of Cruelty to Animals Act, traceable to entry 17, and say that it is traceable to entry 17. I want my lords to just see the act. I'll tell my lords, I'm just going through the act, the way in which the act operates, to show my lords that in pith and substance, this is nothing but an attempt to get out of prevention of cruelty to animals.
We'll note that.
Yes. Yes.
So, I understood where you're going.
Yes. So each provision, what I'm trying to, yes.
We don't have to take us through the act. We have been taken through it, and we have.
Yes, very well. So let me summarize the conclusions now, so that your lordships understand where I'm coming here.
Yes.
In essence, in every provision, first of all, they define what it is.
That's right.
Then in every provision that deals with the protection of animals from cruelty, they carve out an exception to that provision. There's one provision which allows them to make rules in order to conduct it. Now, I am submitting before my lords with the greatest respect that in pith and substance, this is only an attempt to allow and permit cruelty to animals, which cannot fit within, however much you may stretch it.
Argued by Grover. This point was argued by Grover. We have noted it. Anyway, you have even noted it as your argument.
I believe he has not argued legislative competence.
No, he has argued about how you're out talking badly or taking out 11.
No. So let me, no, so he may have made that, but I'm making the connection to the legal constitutional aspect of it. I am trying to say that an act which does this, which carves out exceptions to prevention of cruelty, to permit something which is a finding of fact by this court has been found to be cruel, cannot in pith and substance ever be traced to entry 17 or list 3.
Anything more?
Yes. Now my second submission, my lords, is that it equally cannot be traced to entries
15 and
14 and 15.
14 and 15. There, Mr. Venugopal, we would say that if, depending on their response,
yes,
if I do reply.
Yes. Let me just sketch the outline of the argument. Kindly just take a look, my lords, for a moment at the 7th schedule.
Yes.
Entries 14 and 15, not 15.
15 of the stateless.
Yes.
So it doesn't fall within that.
Agriculture, including agriculture, education and research, protection against pests and prevention of plant diseases.
That's there. So appropriate statement committee.
Yes. Preservation.
The argument. You have pressed the argument. That's what I told you.
Yes. Preservation, protection, and improvement of stock
does not fall
within entry 14, which relates mainly to agriculture, entry 15, which relates to preservation, protection, and improvement of stock.
That's right.
Now, let me just tell my lords that I wanted to I wanted moment.
We will give you the opportunity if it is needed.
Yes.
If they are going to rely upon it, we'll give you the opportunity.
Yes.
Their argument is based on 17. We don't have to go on this argument at all.
Well, if they say they're giving up entry 15, no difficulty. But I wanted to tell my lords.
We are telling you, we'll give you the opportunity necessary.
Yes. I'll only tell my lords why they necessarily have to argue this, because it's in the statement of topics and reasons. My lords,
let's see what they will argue.
They're saying two things, my lords, that it is to protect their culture. Second is they're saying That is the objects and reasons I'm talking about. If your lordships just see, let me just read it out to your lordships.
Yeah.
Where is the act?
You've seen that when you apply.
Yes, the statement of objects and the preamble to the act cites two things. One is culture, that is their native culture and tradition. Tradition and culture, and the second is protection of native breeds of bulls. So ensure the survival and well-being of the native breeds of bulls. So they are likely to try to relate
Let them do that.
to entry 15.
When they do that, you can reply. Yeah.
Very well. May I state the argument at least?
Yes. Okay.
Yes. So the point I'm making is that the word in an entry has to be construed to understand what the entry, the field of legislation covers.
Correct.
Now, the word stock deals with farm animals that are kept. The dictionary definition deals with farm animals which are kept for meat or dairy. I'm talking about the Oxford Dictionary, etc. Now, similarly, there is an act called the Tamil Nadu, which, if your lordships permit, I'll hand over to your lordships. I won't bother to read it. But what I'm trying to say is there is a, lordships may just note, Tamil Nadu Animal Preservation Act of 1958.
Yeah.
Which is for the purpose, and in my respectful submission, can be traced to entry 15 of list 2 for the purpose of preserving animals. Now, in pith and substance, this act can never be regarded as involving the, contrary to the claim, if one reads through the provisions of the act, the provisions of the act are only for regulating, which is what the earlier act also did. However much you may have changed the provisions here and there in order to make it seem like it is protecting animals more or protecting spectators or human more. It cannot be regarded as anything in pith and substance, in my respectful submission, except as an act to regulate exhibition, performance, or competitions involving animals.
That's right.
That's in pith and substance, the act. Therefore, in my respectful submission, if the act intended to protect, preserve, and improve the stock, then it would have provided for things like subsidizing stud farms, or state-sponsored stud farms, etc., making them available to farmers at no cost, the breed, etc. That's one. Second is a native breed of bull, which is built only for the purpose of fighting in these Jallikattu exhibitions. At no stage can be said to relate to agriculture or anything else. So these are the reasons I say it cannot relate to entry 15. So this is now I am going to make the other argument.
What is the other argument?
On Article 21 and place it in a different perspective. I am not arguing, my lords, personhood of animals.
Not arguing.
I'm not arguing personhood of animals or conferring juristic personality on the animal so as to bring it within the ambit of Article 21.
Yeah, what's your argument?
My argument is, my lords, and this is the argument, we have done some research, as your lordships had suggested, on foreign judgments. Now, there are some judgments from Spain which have struck down, as one of my learned friends informed my lords, the ban on bullfighting in Catalonia. But the reason there was that the court said that there are national laws which enshrine that bullfighting is part of the culture of Spain, ancient culture and tradition of Spain. For that reason, the court said that you cannot strike down the ban, that you cannot have a ban on bullfighting in Catalonia, which, as your lordship knows, is a separatist region in Spain. Now, in Mexico, however, where the world's largest bull ring exists, a Mexican judge has banned bullfighting. And this is the argument which I'm going to press before my lords, on the ground that every human being under the Mexican Constitution has the right to a healthy environment. These are
the same argument is addressed already, that Article 21 by a
a right of the human being to clean, safe, pure environment. That argument is already
healthy and holistic environment.
That we will,
So there are various judgments.
that is already answered. So we
There are various judgments of this court which have read into Article 21. I've also heard my learned friend, Mr. Grover, argue before my lords
that
that,
we will note to your, that's your route to Article 21.
yes, Articles 48,
The human agency.
that is, I am the subject of right.
Correct.
I have the right to not be
Subjected to this kind of
subjected
cruel environment.
to cruelty to animals in my environment. And
So
this,
you have no problem with being subjected to the sacrifice of animals for religious purpose. No problem.
I have a problem with that also.
No, human beings eating a lot of animals. You have
There,
no,
I wanted, I wanted to tell my lords.
just being a little selective. That's all.
No.
That's all.
Sorry, I wanted to point out one thing. Within the Prevention of Cruelty to Animals Act, within the Prevention of Cruelty to Animals Act, I wanted to point out.
Gopal, kindly reserve your energy and we are waiting for you to come back to me when the other side replies. That is what we can say. Otherwise,
No, I have something to respond on that, my lords, where I feel a little strongly. I have been representing animal rights, my lords, now for many years.
Good.
Animal rights activists. And the point is,
we can see that that is overpowering you. Particularly at 440 years.
your lordships, my lords, are at a distance. The animal sacrifice matter, my lords, I personally appeared to this before this court. It has been struck down in Himachal.
We are this saying very good. Keep going.
Now, one thing which I wanted to say.
Except on the dinner table. Except on the dinner table.
My lords,
All animals are, the moment they are cooked, they are not animals. Yes.
my lords, may I point out, there is a difference, and this is the fundamental difference I believe,
Between the raw animal and the
between the point that your lordship is making is, my lords, the argument which makes it reductio ad absurdum. There is also another argument my lords have employed, which is called the slippery slope argument in American law schools. That is the mosquito argument, the boxing argument on consent, etc. Now, the submission I am making is there is a distinction which Mr. Devan has brought to my lord's notice. It is one thing to say, and this I wanted to.
as long as they are alive, they have to live with dignity. That is what you're
More than that, I'm saying even under the Prevention of Cruelty to Animals Act, your lordships may kindly see the slaughterhouse rules.
Yes, that's right. We know that. There are
No.
various rules which are there.
No, I want to point
When
out
the animal dies, a human being lives.
death per se, my lords, happens even
End
on
of
the
the day,
savannah in
human being
Africa.
lives.
No, I'm saying death happens even on the savannah in Africa. And no animal rights or activist protests at that.
Absolutely.
But the two are different. The two are fundamentally different, my lords, because we, as human beings,
Have a right to.
are so powerful in terms of our technology, our ability to band together, that imagine, my lords, and this is an example that I wanted to place before, my lords. Imagine, my lords, that there is a species with superior intellect. Let us assume it is an alien species that
Means suzerainty over us.
farms humans for their purposes. Would your lordships then concede that the treatment that is accorded to us is
All right, Venugopal, we will.
permissible?
Let us bring the curtains down.
No, I have one submission. Your lordship may just see Rule 6 of the Slaughterhouse Rules for 1 minute.
Yeah.
If your lordship just takes the Bear Act and comes to Rule 6,
Yeah.
I just want to place that
All right, rules say.
of the Prevention of Cruelty to Animals Slaughterhouse Rules.
We will note that.
2001, Rule 6, no animal shall be slaughtered. I'm saying even in slaughter. And rules, as your lordships know, have to be treated as part of the Parent Act
Correct.
because they're placed before Parliament.
We hope you say that about the Tamil Nadu rules also.
You know,
When it comes to the Tamil Nadu rules, see, it's not part, because somebody said not a way. Right, you correctly pointed to the real position in law. Yes.
yes, but for one thing, Lawrence, that this is not a rule which is placed before Parliament. It is only in the Tamil Nadu legislature. And this act, though it doesn't say so, applies only in the state of Tamil Nadu. Now, just see, let me just tell my lords, the protections in Rule 6. No animal shall be slaughtered in a slaughterhouse in sight of other animals. 2. No animal shall be administered any chemical, drug, or hormone before slaughter except drug for its treatment from any specific disease or ailment. 3. The slaughter halls in a slaughterhouse shall provide separate sections of adequate dimensions sufficient for slaughter of individual animals to ensure that the animal to be slaughtered is not within the sight of other animals.
All right. We have seen that.
And every slaughterhouse, as soon as possible, shall provide a separate space for stunning. For stunning of animals is mandatory before.
Whatever you want to say, we put it down in writing now. Let us come to that. Who's appearing for the Karnataka?
I have only one fear, my lords. Your lordships will be laying down law that defines animal rights for the conceivable future in this country.
That's right.
If your lordships do not take account, my lords, of all the facets of animal rights, I'm told that your lordships wanted to see the philosophical sort of basis for animal rights.
Yeah.
I have a couple of articles. Would your lordships like me to
pass it on? Pass it on. We will see.
Very well.
Pass it on. Give a copy.
Along with your notes.
Very well. We'll do that, my lords. I don't want to hold up my lords when your lordships are in such a hurry to bundle me out.
Thank you.
I'll accept it.
No, thank you.
And one more thing, my lords.
Who's appearing in the
one more thing. I wanted to cite 2 judgments.
Give the cite that we can cite it.
State of Gujarat versus Mirzapur Moti Qureshi. Yes. 2005, 8 SCC. 534. 7 judges, Justice Lavati, my lords. This is the Chief Justice Lavati for the House. It's been
cited by somebody.
Yes.
Cited by.
No, it is cited but not read. But the only point I'm making is that 48 and 51 page are read in to say that cow slaughter cannot be, that is, uphold a law banning cow slaughter.
How do you know it was not read?
Well, it's because I have people.
Immediately when you said author is Justice Lavati, you come across this no cited.
It's been cited but not read. Is what I was
appearing in the Karnataka matter.
Very well, my lords, I'm great.
What is the other day?
The other judges, the 5 judges, Mohammad Hanif Qureshi.
That again counts.
Yes, this is on the regulations of entry 15, and that it is working bulls and that is cows for dairy, working bulls and bullocks.
Who is appearing in the Karnataka matters? All the petitioners.
On the lighter side, earlier when we have seen the cricket matches, it was a test match. And we came across 50 overs.
And now
it is 20 hours a night. So, see the change, how it comes.
So who is appearing in the Karnataka matters for the petition?
I don't know, my lords.
Who else is there in the Karnataka matters?
I appeal for the state.
Who is appearing? So he's covered by Karnataka also.
Yes.
So there is nobody else to do deal with Karnataka. Then who is appearing in the Maharashtra matter? Yes. Please make your submissions. What is it? You're appearing for.
And for one of the intervener.
In which case? Tamil Nadu. In the Tamil Nadu matter, I will intervene. What is it?
There are, sir, I want to only raise three points and then I will give the citation lordships. 3 points. One is that.
What is your name?
My name is Kamal Mehta.
Kamal Mehta
from
you.
Ahmedabad.
Okay. Just give you 5 minutes.
I give you lordships 5 points because your lordships are overworking.
Yes.
And who are you? One is when your lordships are dealing with Nagaraj in a constitution bench.
Yes. Your case, you tell us in which petition are you the intervener?
Huh?
In which petitioner are you the intervener?
My intervention application 23 of 16. It petition 23 of 16.
Okay.
My intervention application is 179-720-2022.
All right. You are intervener. And what is your client? Who is your client?
Animal Foundation. I'm pro bono appearing.
All right. So what are your 5 points quickly? Just tell us.
When your lordship is dealing with Nagaraj case in a constitution bench, my submission is that your lordship are going to lay down animal rights of for the country in a constitution bench. So my respectful submission is that before earlier, your lordship had to say 2 judgments. One is a 58 Supreme Court, that is Qureshi case first.
Yes.
AIR 58 Supreme Court 731.
731.
There even when lordship mentioned about that Bakri, that the Supreme Court said that the Muslim has no right, even on Bakri. That is paragraph 13 on page 739, sir.
Very good.
Then second judgment is also regarding constitution bench judgment. That is AIR 86 Supreme Court 1213.
1213.
And paragraph 15 and 16. Paragraph 15 and 16. And the third is the Mirzapur judgment,
which is already cited.
That is already cited. The only thing I want to say, that in that case, Supreme Court was dealing with Article 48, 48A, 51AG, and they interpreted.
Yes.
That is why it is a 7-judge bench. Then second, another points I want to say that 51, your lordship, when interpreting Article 51A, then it is a fundamental duties. Now, and your lordship has yesterday discussed with rights and duties.
Yes.
But before introduction of fundamental duties, Supreme Court in AIR 1970, Supreme Court 2042, para 13 said that there can't be only right, there should be a duty together. In 1970, Supreme Court, before introduction of fundamental duties. And another important judgment is AIR 2001 Supreme Court 3262, para 52, where Supreme Court said that the interpretation of all laws has to be in consonance with fundamental rights, fundamental duties. And third, the animal rights and wildlife right has impact on environment. That first judgment is AIR 89 Supreme Court page 1. Justice Venkat Chalaya's judgment.
AIR 89 Supreme Court page 1.
AIR 89 Supreme para 4 and para 7. And thereafter there are 2 judgments. 2020.
There are any number of judgments.
I will give that gives a wide rights of animal rights. That's a.
You give the.
Citation. And another I want to cite, only one. Another I want to cite one article of this Prasna. That I will cite. And another 2 articles which are published. In support of that, I will give some.
Thank you.
My submission is that your lordship can decide, but your lordship have full assistance, and then your lordship decide. That's the only submission.
Thank you. Yes, now who is for the Maharashtra? We finally come to that. So Karnataka is over, we take it, nobody else is to argue.
We may still like your lordship have heard after 4 o'clock.
That's all.
Kannada was 1152. 1152.
Now, yes.
There are 2 preliminary submissions which I want to make because the question would. I may not have serial number 14.
What is
the petition number 60 of 2020?
60
of 2020. This was originally the petition. Yes. This was the original petition which was filed in the Bombay. Thereafter, an interim order was passed in our favor that was challenged here by SLP. The transfer petition was filed. And
what are the prayers in your petition?
That Maharashtra Act may be declared as invalid. Give me some time. I will not repeat anything. And I need to tell 2 things here.
What you are adopting, first of all, we'd like to know whether you're adopting arguments of counsel.
Some argument, and there I would only say this is the proposition which I am adopting.
Adopts arguments.
Give me some time. I will tell you, Lordship, that what is really the difference between Jallikattu and Maharashtra Act. I will not tell you, Lordship, that Maharashtra is about.
Where is the Maharashtra Act? Let us
Act is that your Lordship would get in that common compilation.
Please give that Maharashtra Act.
It is page 141, the common compilation. Volume 1, page 141.
This thing is
That is document number 50.
Yes. It is shown as a bill, but actually, the act has been passed. That is an negative. In the compilation, it appears it is only the bill which is there. Naturally, a question would arise that what is really the difference between Jallikattu on one hand and the bullock cart races in the Maharashtra on the other? I do not propose to give your lordship any graphic description of the bullock cart, because for the purpose of deciding the legal point, that graphic description either of Jallikattu or of the bullock cart race is completely irrelevant. I will not take your lordship.
your case, was it considered in the Nagaraja case, Maharashtra, this bullock?
Maharashtra, and I tell your lordship that what is the difference. The first difference between the Tamil Nadu and Maharashtra is this. Tamil Nadu, your lordship knows that 2009 the Amendment Act came to be passed. Validity of that amendment came to be challenged by
Amendment Act, it is an act.
Sorry?
It is not an amending act, it's an act.
It is the title of the act is the Prevention of Cruelty to the Animal, Tamil Nadu Amendment Act.
No, but nonetheless, not an act.
Of course it is an act. I said that. I also said. Separate act.
It's not a Prevention of Cruelty Amendment Act in
Well, I-
2009. We are talking that takes place only in Turkey, in Tamil Nadu.
I stand there.
Original act is 2009.
This 2009 Act came to be passed. That 2009 Act, virus of that was challenged before the Supreme Court. And in the year 2014, in the judgment of A. Nagaraja, that the Act was declared as unconstitutional.
But let us see the
Maharashtra, there was no such Act.
that's
Maharashtra, there was no such Act. Maharashtra Act came to be passed for the first time only in the year 2017. There was no 2009 Act.
that Amendment Act, first of all.
Which one?
Amendment Act. in
Maharashtra? Yes, that is
Page, we got a compilation with it. Page we take this.
141. 141.
Let's see if it is.
First one. First one. In the no.
You are the first one.
The preamble says, whereas it is expedient to amend the Prevention of Cruelty to the Animal Act 1960 in its application to the state of Maharashtra, for the purposes hereinafter appearing, it is hereby enacted and so as under. And then your lordship will kindly go to section 3. First, we go to the definition of the word bullock cart race by section 2 of the Amendment Act. BB. Bullock cart race means an event involving bulls or bullocks to conduct a race, whether tied to a cart with the help of a wooden yoke or not, by whatever name called, with or without a cartman, with a view to follow the tradition and the culture on such days and in any district where it is being traditionally held at such places as may be previously approved by the district collector, and also include Bailgada Sharia, that is a Marathi phrase, Bailgada Sharia, and Shankar part in the state of Maharashtra. These are the local language usage which have been described that particular activity. Then please go to section 3. Notwithstanding anything contained in subsection 1, the bullock cart race may be conducted with the prior permission of the collector subject to the condition that no pain or suffering as envisaged by or under the act is caused to the animal by any person or the person in charge of the animal used to conduct the bullock cart races and subject to such other condition as may be prescribed by the rule under section 38B, capital B of the state government, by the state government. If any person or persons in charge of the animal conducts bullock cart races in contravention of the condition laid down in subsection 2 or the rules made thereunder relating to the bullock cart races or causes pain or suffering to the animal, he shall be punished with swine. Then your lordship will kindly see section 11 is amended by amendment section 4. C1. The conduct of bullock cart races in accordance with the provisions of subsection 2 of section 3 or the participation therein with a view to follow or promote tradition and culture and to ensure the preservation of the native breeds of bulls and also purity, safety, security and the well-being. This is in 11.3 where the 5 exceptions have been already carved out.
clause A to clause E. Then your lordship will see section 22, where a proviso is added, my lord, to section 22, provided that nothing contained in this section shall apply to conduct of the bullock cart races in accordance with the provisions of section 3, subsection 2. Then 27, my lord, is amended by Amendment Act section 6, A1, to conduct of bullock cart races in accordance with the provisions of subsection 2 of section 3, with a view to follow and to promote tradition and the culture and ensure survival and the continuance of native breeds for the bulls. Then your lordship will see 28A. Nothing contained in this section shall apply to the bullock cart races conducted in accordance with the provisions of subsection 2 of section 3, to follow and promote the traditions and the culture, and such conduct shall not be an offence under that. And then 38B, if your lordship permit me, I will like not to read because that is the rule making power, which is expressly my lordship. Now please consider there are two differences between Tamil Nadu and us. I will be very brief and I will only give my proposition. First difference between Tamil Nadu and us is Tamil Nadu had in 2009 Act, which was challenged, of which virus melod was declared as unconstitutional in 2014. Maharashtra never had any such act. Maharashtra Act came for the first time in the year 2017, is difference number one. Difference number two, my lord, is that if your lordship see the provisions of section 3 amendment by section 2, my lord, of the Amendment Act, and please see clause 2, and in that clause 2, kindly straightway go to that crucial phrase, my lord, which repeatedly your lordship, my lord, must have read, my lord, in the main principle act. That is, my lord, in the third line from the top, words are pain or suffering. The submission, my lord, is this: if your lordship sees section 3, clause 1, your lordship will see the preamble of the Amendment Act. A very important phraseology has been used, my lord, in the Principal Act, and that, my lord, is, and as your lordship, my lord, with respect said rightly, for that purpose. That is what the preamble says. What is that purpose? In my respectful submission, the purpose, my lord, which is contemplated by the Principal Act is unnecessary hardship, unnecessary pain and suffering. That word unnecessary is conspicuously absent in section 3, clause 2 after the amendment, my lord, by this. Whereas, if your lordship compare the provisions of 3.2 as amended by Karnataka, which I will show to your lordship, the word unnecessary hardship and suffering is there.
No, but it says subject to the condition that no pain or suffering as envisaged by or under the Act.
So that
pain can only be unnecessary.
Now the submission is that although it is true that section 3, clause 2 starts with a non-obstantive clause. It starts with a non-obstantive clause. Notwithstanding anything contained in subsection 1, so prima facie one gets an impression that it would override 3.1. But thereafter, because of this phraseology, no pain or suffering as envisaged by or under that. Mark the word as envisaged by or under that. Submission before your lordship is twofold. One, the phraseology as envisaged by or under the Act means the Principal Act. We have to see that what type of suffering is contemplated or permitted by or under the provisions of the Principal Act, and only that has been allowed by the Maharashtra. In other words, despite amendment which has been made in the Principal Act, because of this phraseology, namely pain and suffering as envisaged by or under that, as envisaged by or under that would mean that only that pain and suffering which is permitted by the Principal Act alone is reintroduced, notwithstanding the non-obstantive clause. Therefore, my submission before your lordship is twofold. First submission is the effect of the non-obstantive clause at the beginning of section 3, clause 2 is mellowed down by virtue of the fact that instead of using the phrase as Karnataka used, namely unnecessary hardship or unnecessary suffering, they have used the word the hardship or the suffering, pain or suffering as envisaged by or under that. If your lordship want to find it out, what is really meant by the word as envisaged by or under that, Please eclipse that phrase and read that. And thereafter remove the eclipse and find it out what difference it makes. In my respectful submission, by introduction of the phrase as envisaged by or under that, the entire principal act has been reintroduced. Therefore, the net result will be that notwithstanding the amendment made in the Maharashtra Act by this offending act, the act of which virus I am challenging, if it can be shown that the suffering and the pain which is envisaged by or under the principal act is only that suffering or the pain which is permitted there, namely, A, it must be necessary. B, it must be necessary either for the animal kingdom as contemplated by section 24, or it may be necessary for vegetable kingdom as contemplated by section 24, or it may be necessary for the purpose of food.
That may not be the correct way of reading it. You come to section 11 of the Act.
Principle.
11 of the
Principle.
principle.
Just give me one.
You see, section 11 enumerates acts which are treated as acts of cruelty.
Yes.
Correct? For example, you read 11A, 1A.
Yes.
Beats, kicks, override, overdrive, overloads, tortures, or otherwise treat any animal. They're not acts of cruelty.
Yes.
So what is emphasized in the Creed 2 appears to be that you can have this bullet race, but please don't beat, please don't kick, please don't override, please don't overdrive, overdrive, overload, torture, or otherwise treated as unnecessary pain. Bullet can't can go. Now, if you take each one of the subsections of 11A, of parts of 11A, now employees in any work or labor for any purpose, any animal, by reason of infirmity, wound, etc., that willfully unreasonably administer the injurious drug, it cannot be done.
May I respond?
That's what is intended. Conveys, keeps in so and so.
May I respond, sir? No, there are three responses I want to give, which again I will give in the form of proposition without elaborating them. A. There are three propositions, and as I said, I will not elaborate because I know that I am batting in the mandatory over, and therefore I will not take much time of yours. Three propositions in response that I am indicating to your lordships are this. A. Each and every clause in section 11, be it A, be it D, any clause, and I will not take your lordship's time in reading this because even to your lordship's eyes also it will become very clear. A very important phrase has been used, namely unnecessary pain or suffering. That word is conspicuously present in Tamil Nadu. I'm sorry, Karnataka. Is conspicuously absent Maharashtra. It is sought to be reintroduced by this peculiar phrase, namely as envisaged by or under the Act by Maharashtra.
Pain as emphasized under the Act is unnecessary pain.
No, sir. I tell you a lot. I give an illustration to you. There are
11.1D, 11.1D.
11?
1D.
11.1D. Conveys or carries wherever in or upon any vehicle or not any animal in such a manner or a position as to subject it to unnecessary pain or suffering. This adjective unnecessary, sir, is everywhere. Now, my lord, natural corollary, my lord, of this will be that if this is unnecessary, what is really necessary? And that I want to answer as a second proposition. What is necessary under the Act? Pain, every pain, my lord, every pain and every suffering is not prohibited. Unnecessary pain and suffering is prohibited. There are some necessary pain and suffering. For example, 5A. See the provisions of 11.3E. Food. Absolutely necessary, my lord, for human existence. It is the pain to kill an animal. To whom? Sorry?
Absolutely.
according to whom it is necessary.
Not for the animal, actually the animal will never say.
Obviously, my lord, humans. Obviously, humans.
Prejudice,
Therefore,
class bias.
it is for the legislature, my lord, to make that exception. I am only saying that which are the exceptions.
And again, in Homo sapiens, there are vegetarians.
Yes,
So they may not be liking this.
Lord, may I say one thing? I am only indicating to your lordship that which are the exceptions which are called out and what is common element in all of them. This is one exception which is called out 11.3e. Second exception which is called out is performance of the experiments as contemplated by 24. Now, if your lordship see the last part of 24, it uses three phrases. Experiment for the benefit of animals actually, plural. That means animal kingdom. Benefit of the plants, that is vegetable kingdom, and benefit of the animal. This is second, which is not accepted. Third, which is accepted, is that if an animal is suffering, and sometimes the only solution in the suffering is death, then there is a specific provision which says that you can extinguish the lamp of the life instead of allowing that animal to suffer. Fourth, which is permitted, is for the purpose of section 28, namely for the purpose of religious practice. So the common element in all the exceptions which have been carved out by the principal acts are twofold. A, it must be necessary. That is why the doctrine of necessity has been commented upon in Nagaraja Jaji. B, whenever there is a conflict between human being on one hand and the necessity of the human being on one hand and the animal, the legislature has always favored in favor of necessity of human man. But necessity is different from entertainment and amusement. In my respectful submission, by deleting the word unnecessary, the Maharashtrian Lord has thrown open the field also to unnecessary suffering and pain.
Deleting unnecessary.
By deleting the word unnecessary in 3.2.
You're saying unnecessary has been deleted.
Unnecessary has been deleted. If your lordship at this juncture, kindly go to Karnataka and Tamil Nadu for a minute.
Forget about that. Why do you say unnecessary has been deleted?
The word unnecessary is not there, Lord, in fact. In Maharashtra, that word is not.
No, it is there in the parent act.
No, in the parent act it is there.
The amendment would be saying that pain as envisaged in the act shall not be caused.
Therefore, I am saying that
Therefore, what is that pain? That is unnecessary pain.
So, therefore, I am saying it is not only unnecessary, but it is that which is permitted by the principle. In my respectful submission, the correct
Permitted by the act, nobody can take exception.
in that eventuality, sir, in that eventuality, the natural consequences will be that if Bailgada Sharia, the bullock cart race, if it is prohibited by the principal legislation, by virtue of this clause, that prohibition gets reintroduced, is my submission. Because of this phrase.
Now, what happens in the Maharashtra, unlike Tamil Nadu, it is not a fight. It's no flight fear. What is involved is a race.
Lord, may I tell you?
There is a qualitative difference.
Lord, may I
There
tell
is
you?
a qualitative difference.
Lord, may I tell you?
Yes. What happened?
In both the places, I tell you, Your Lordship, what is the difference and what is common fact. Firstly, let me, in reply to what falls from Your Lordship, let me tell Your Lordship what is the difference. In case of Jallikattu, I believe, I have never gone to that land and I have never seen that thing. But from whatever photographs I have seen, it appears that the bull is permitted. Initially, it was kept in a captive, and thereafter it is permitted, and it really enters into the mob, the ring. The first reaction of the bull is to fly away from them. And they, I don't know. But I'm not saying this. I'm only describing the game. I'm only describing the game. I'm not saying this as an authority or any proposition. I'm only showing that what is common there and here. The existence and the presence of mob, which per se is fearsome, is common both. Bullock cart also, lot of crowd, there also lot of.
Again, where is the empirical evidence of this?
No, I'm only what the submission.
You see, bullocks can be used for a man's purpose, for carrying man, the weight, all his food articles, whatever is the weight that you can use.
Of course I can do.
So bullocks can take the load of that weight.
Yes.
There is no cruelty in that.
No cruelty.
Accordingly.
No cruelty. I tell you, Your Lordship, why there is no cruelty.
There is no cruelty.
I tell you, Your Lordship, why there is no cruelty. Because my lord, the bull, because of his physical attribute, is in a position, my lord, to work, my lord, as an animal for this purpose. There are rules which have been framed under the Principal Act. The rule,
By making the bullock work itself is causing pain.
No.
The bullock may
No, I tell you, Your Lordship.
like to be under a shade.
No, sir. I tell you, Your Lordship. Just give me some time, my lord, to explain this. If I make a statement that irrespective of that rule that Your Lordship mentioned, the bull can be compelled to carry any weight, that will be cruelty.
But is it not an intrusion into its liberty?
It is, undoubtedly. But liberty is not available to him. I don't think that personal liberty contemplated by Article 21 is available to
Not available. Let us make a note immediately.
Yeah.
Otherwise, you will have to close all the zoo. It has to be closed.
Sorry?
Personal liberty is there.
I'm not saying for a minute also, my lord,
The
that
next moment you can speak.
I'm not saying for a minute also that Article 21 should be construed. However liberally you construe, to say that animal would be a person, it will be difficult.
The Article 14 also uses the
That I believe Mr. Diwan, my lord, had some difficulty. He had given the answer. I leave it to your lordship. I do not want to say that.
What you're saying that liberty also person is used, whether it will include the bullocks.
No, it won't.
So both
Because my lord, if that adventurous argument is made, then the next adventurous argument will be that bullock has a fundamental right to move freely under the provisions of Article 19 because bullock is a citizen. That will be the next point, my lord, of the argument. So I do not want to go by that way. I do not want to make that argument. I want to make only two arguments before your lordship.
Therefore, what is you're challenging?
I tell you.
You're challenging a law.
I tell you.
What is your ground for?
Yes, I have three propositions. My first proposition your lordship have taken. Please allow me to make that repetition so that my proposition goes clearly to your lordship.
Yeah.
My first proposition is the manner in which the amendment has been made by Maharashtra and the manner in which non-obstantive clause has been used. But the teeth of that non-obstantive clause have been mellowed down by deleting the word unnecessary, but reintroducing that by that peculiar phrase as envisaged by or under the Principal Act. In my respectful submission, all that cruelty, only if it is permitted under the Principal Act, alone is reintroduced in Maharashtra.
Amendment made by Maharashtra reintroduces Section 11.
Section 11.
Section 11 is
Section 11 coupled with, my lord, all other sections which I said, namely Section 24.
All are reintroduced.
All are reintroduced. Because of that phrase.
Because of the way the amendment is planned.
Absolutely. And my lord, I would request, and I will not take time of your lordship, in comparing the provisions of amendment to Section 3 of the Maharashtra Act with the one which has been made by Tamil Nadu Act and the one which has been made by Karnataka Act, I would request your lordship may
Go to the next point.
write on the page number only. I will immediately go to the next.
Tell us the point.
You can tell us the point. What is the second point?
The second submission, my lord, is this. Three submissions I want to make. I formulate them immediately. Your lordship, I formulate a submission straightly. For the purpose of deciding as to whether the rock foundation of the judgment is destroyed by the legislature by legislatively overruling the judgment of the court, which is permissible mode in our constitution. You have to see the statute.
That was also.
No, sir. Reliance can't be placed on subordinate legislation, namely the rules. I did not say that I'm advancing the argument. I'm only saying that I will make the proposition and I will leave that. I know that this point has been argued. I'm only putting it in my words. The proposition, three propositions I want to say. The first is this. If you want to say that the act has destroyed the foundation of a Supreme Court judgment, the roots and the material to find out whether it has really destroyed it or not has to be present in the soil of statute.
But in your case, this court has not examined.
No, no, I'm only saying that your lordship is right. In my case, this has not been. In my, but
your case after the amendment,
but sir,
legislative wisdom has given.
but sir, para 72 and 73, my lord, of the judgment given by the Supreme Court, even in the matter of Jallikattu, clearly says that conducting the bullock cart races is per se and highest degree, my lord, of the cruelty. Para 72 and 70. In other words, although Maharashtra Act was not under the microscope of the Supreme Court, my lord, in 2014, and to that extent, my lord, the Tamil Nadu, my lord, differs from us. Nonetheless, if the Maharashtra legislature wants to do an act which, my lord, would set aside the judgment, my lord, of the Supreme Court in 2014, it can do that undoubtedly, and for that no judgment is necessary. It can undoubtedly do that. You have to destroy the rock foundation.
Our act has not seen the light of the day when 14 judgment came in 17.
Yes. No, I'm saying that if you want to destroy the judgment of 2014, para 72 and 73. Para 72 and 73, my lord, protects me.
Let us see the para 72 and 73.
Yes, you will also see para 72 and 73.
That's the end of the matter.
May I read?
Yes.
I read 73, my lord, straight up.
Yes.
Jallikattu and the other forms of the bull races, as the various reports indicate, cause considerable pain, stress, and the strain on the bulls. Bulls in such events not only do move their head, showing that they do not want to go to the arena, but also the pain inflicted by so and so is so much. They have no other go but to flee to a situation which is adverse to them. Bulls in that situation are stressed, exhausted, injured, and humiliated. Frustration of the bull is noticeable in their vocalization, and looking at their facial expression of the bull, ethologist or an ordinary man can easily sense their sufferings. Bulls, otherwise very peaceful animals, dedicating their life for the human use and the requirement, but they are subjected to such an ordeal that not only inflict the serious suffering on them, but also forces them to behave in the way, namely they do not want to behave, force them into the event which does not like, and in that process they are being tortured to the hill. Bulls cannot carry the so-called performance without being exhausted, injured, tortured, or humiliated. Bulls are also intentionally subjected to fear, injury, both mentally and physically.
Para 71 also helps you.
Which one, sir?
Para 71 also helps.
Yes, sir. Yes.
You can read para 71.
Yes, I am deeply obliged to you, Lord. Non-essential activity.
And lastly, 90.
Last.
Direction in 90.
Yes. 91, I think.
No, it's 90.
71 you
90.
71.
Consequently, the bulls cannot be used as a performing animals either for the Jallikattu events or bullock cart races in the state of Tamil Nadu and Maharashtra.
So, my lord, in my respectful submission, firstly, I will read para 71 as your lordship asked me. But, my lord, if your lordships have read it, my lord, should I read that?
We have read it.
I do not read it. Your lordships have read it, my lord, that is it. In my respectful submission, the query which was asked, my lord, by your lordship, to that, my lord, my answer is that although to that extent I differ, my lord, from Tamil Nadu, in my respectful submission, if there is a Supreme Court judgment which protects, my lord, the Maharashtra bulls, my lord, from the bullock cart races, if you want to destroy that, only way in which you can destroy it by rocking down the rocking foundation of the judgment is required to be destroyed. Now, if you want to find out whether the rock foundation is destroyed or not, the soil that you must test is the legislative soil, not the rules. Because the rule is subordinate.
Anyway, first you have coined the new word, legislative soil. Good. Legislative soil, yes.
Lord, I give an illustration to your lordship. Please permit me, Lord, to give this illustration. Suppose, my lord, the law is passed, my lord, on 1st of January 2022. Your lordship, suppose, has delivered a judgment in the earlier year. A law has been passed on 1st of January 2022. Rules have been framed, my lord, on 1st of November 2022. If your lordship, for the purpose of finding out whether the rock foundation of your lordship judgment is destroyed, want to consult the rules, subordinate legislation, then what will be the position of law between 1st January 2022 to 1st November 2022? Therefore, in my respectful submission, the only correct way not to deal with by the government of Maharashtra was this. A, they should have found out what is really that foundation of the judgment of Milord 2014. What is that which is rock foundation? Because the judgment, Milord, is pregnant with some Milord foundational facts, some, Milord, are supportive facts, some are supplementary, and some are only in the nature of pious wishes. And one of the directions which has been given is Parliament should consider this. In my respectful submission, if you want to adopt this principle, two questions are required here. One, what is exactly that rock foundation of 2014 judgment? And two, is that destroyed by statute, not rules? And my second submission is this. And the third submission, sir, is I will give a note also, Milord, so that Milord, the third submission, sir, is this. If I ask this question that, Mr. Anturkar, according to you, what is the rock foundation of 2014? I may say, the following three are the rock foundation. There may be more than also, but I confine myself only to following three. A, doctrine of necessity and not the unnecessary activities. And your lordship may just take the paragraph number, and as I promised your lordship, I will not read the paragraph. Relevant paragraphs, Lord, on this are para 71 and paragraph 41 and paragraph 40.
40 and 41.
Sir, 41 and 40 and paragraph 70, which decides about the doctrine of necessity. And the first foundation, therefore, is anything which is necessary is allowed, anything which is unnecessary is required to be prohibited. And necessary from the obviously, firstly, from the point of view of human mind, human, secondly, other animals, thirdly, plant, and fourthly, that animal itself, because sometimes you are required to kill that animal, because the only way out, Milord, of the death is the sometimes only way out. The second pillar, the 5 freedoms, Milord, of the animal, and that your lordship may take the paragraph, para 64.
See that we have been pointed to. 5 freedoms.
Para 64. I do not read the paragraph
It's already been read.
And so many times it has been read, and I am bound, Milord, by the promise. Third, a clear finding of fact recorded in para 72 and 73 at Jallikattu or Jallikattu, Milord, I may be pronouncing it wrongly possibly, or the bullock cart race is per se and most cruel form. This is the finding. These, in my respectful submissions, are the 3 pillars. As I indicated to your lordship, there may be more than that also. For example, in some paragraph, their lordships have referred to international. Some paragraph, they have referred to international treaty. But to find out the foundation of the judgment, you have to find it out, which is that part, which if it would not have been there, this conclusion would not have been achieved. That is the test. International, Spain, Brazil is irrelevant. It may be supporting. That is not foundation. Foundation is these 3. And I repeat, it may be more than this also. But I confine myself to these 3.
So I think we have heard you.
Sir, only one. Only one. I am done. Give me 2 or 3 minutes.
Yeah.
To find out that whether that foundation is destroyed or not, please go to that Maharashtra Act, and I want to show only one section.
Yeah.
Your Lordship will go to that Maharashtra.
Sure.
And please see the preamble and compare in the mind with the preamble of our principle. Just see the preamble. Only one section, sir, I want to show. I do not want to take more time of yours. See the preamble. I not got it?
Yeah.
Whereas it is expedient to amend the Prevention of Cruelty to the Animals Act in 1960 in its application to the state of Maharashtra. See the next phrase, sir. For the purposes hereinafter appearing. And compare with the purposes which have been mentioned in the preamble of the principle. Which are the purposes hereinafter appearing? Which are those purposes hereinafter appearing? And where they are appearing? That section I want to show to your Lordship. And that section, my Lord, is section 4 of the Amendment Act. Please see the purpose. See the purposes. See the purpose. The conduct of the bullock cart races in accordance with the provisions of subsection 2 of section 3 or participation in it with a view to follow and promote tradition and culture, ensure preservation of native breed of the bull, purity, safety, security and well-being. Now suppose if these purposes are accepted, the first pillar of necessity remains intact. The second pillar of 5 freedom remains intact. The finding that Jallikattu and bullock cart races is per se excruciating remains intact. Principal Act does not say that for the purposes mentioned in section 4, the cruelty is allowed. That is not a necessary cruelty. In other words, a cruelty which is avoidable and which is for the purpose of entertainment and amusement is prohibited. But something which is necessary is unfortunately allowed and rightly allowed. In my, sir, if your Lordship give me 2 more minutes. I tell you, Lordship, why. I want to address you about that culture. Culture. Article 20. It will not take. I will not read it.
It's by the clock, yes.
Your Lordship, culture, my Lord, is one of the things which has been mentioned. Councils after councils told your Lordship that suppose if this culture argument is accepted, because unlike many other provisions, take the case of Article 25, subject to the other provisions of this Constitution, that is how it starts. All other articles also start subject to this provision, subject to that, or notwithstanding anything contained in Part 3, notwithstanding anything contained in this Constitution. There are various ways. There is no such clause in Article 29. Now, if Article 29 is given its fullest effect, namely, that if I can show that I have this culture and I have this tradition, then I have a fundamental right for this. Just imagine what would happen about untouchability. What would happen about sati? What would happen about child marriage? In my respectful submission, 2 propositions I want to say in answer to the culture argument. A, anything which is prohibited by Constitution ceases to be culture and a tradition for the purpose of Article 29. If Constitution says untouchability is bad, it ceases to be custom.
Yeah.
2, even if it is not prohibited by Constitution, it is prohibited by law. Then applying the ratio of Khode distillery, or the judgments where your Lordships have taken the view in case of fundamental right to carry on the business would not include fundamental right to carry on the business in liquor. So wherever a particular business is prohibited or regulated by law, Article 19. In the same fashion, if it is prohibited by statute, Article 29 also may not squeeze itself for the higher end, and that higher end may be found either in Article 51A, G and H, or it may be found in the fundamental right of religion. That is why we have section 11(3)(e). Sorry, not 11(e), 28, sir. 28. Sacrifice. So, in my respectful submission, that argument of culture is required to be mellowed down for the purpose of the fundamental duty, other provisions of the Constitution, and equally other statutory provisions. I am so deeply.
Thank you. Thank you. You have stuck to the time and you have been very consistent. On tomorrow, States Council will be heard. Union and respondents will begin at 10:30.
Here, 1 minute. Of course, what Mr. Sibal would. I am for Union of India as well as State of Maharashtra. Not take after them.
There is only one thing we would like to put to you. There is this one argument that when the assent was given,
The repugnance.
whether you will have the files with you, you will actually go through it. So
I will go through.
So that let us see if so we
I'll
can
go through the file.
in case it is
Honorable
necessary,
President.
you would have no problem in producing it to us. It's not a matter of.
Lordship, I have one read petition in Maharashtra case supporting the legislation on behalf of the farmer. I will make my submission after state submissions will be.
Who are you?
I am appearing for one of the farmers who is read petitioner here, whose read petition is referred to this bench by the.
What is your petition for?
Read petition for.
What is the prayer is that?
Prayer is that the challenge to the Maharashtra Act violates farmers' right to livelihood and right to occupation.
You don't understand. What is the prayer in your petition?
Supporting the.
I know that, but what is the prayer?
Prayer is that our case is that large sizable population of the state.
A declaration you are
What is your prayer? Relief, you just tell us what's your relief.
First relief is
The High
that
Court should not interfere.
challenge to the act violates fundamental rights of the farmers. This should be
The Act violates.
challenge to the act in support of the legislation. Yeah, I will make my submission.
It's 5:30, and in that paragraph 73, the bulls being humiliated is also recorded, right? Now, Mr. Venugopal, to the dry bones of law, he brought a bit of a blood and thunder, blood and gore, and he's talking about Spain. There's a bit of a debate there, whether the bulls actually get attracted by the red flag, which are shown at them and then the charge. And my brother, Justice Joseph, said that bulls are actually colorblind. It is the female species, the cows, who are attracted by the color. But then why do bulls charge? The bulls charge because somebody is mistaking them for cows.
That was really one of the.
Actually, the bulls are colorblind. The bulls can't see either green or the red color. Cannot see. We have this myth.
Result of change in gender, Manoj, which.
That's what my brother Joseph pointed out yesterday.
You don't call me.
Animal Welfare Board of India. I have given my written submission, my lord, so I do not repeat my arguments.
Who are you?
Animal Welfare Board of India.
Same argument.
No, not the same argument. See, legislature have.
What are you a writ petitioner or are you a?
I'm respondent also in other petitions, my lord.
Are you a writ petitioner?
No, the first petition was challenging the notification, which
That's
put in the.
They filed writ petition. They have filed written submissions, Malaj. That's all she wants to rely upon. That's all, nothing more than that.
Supporting the petitioner.
Yes, ma'am.
That's
You
all.
may not take a neutral stand.
No, they've not taken a neutral stand. They've taken a positive stand. Supporting us.
Neutral stand means what?
Lords,
Even when you take a neutral stand, you'll have a stand. No, we'll have to know. Neutrality has got a lot of meaning. Neutrality means a lot of things.
Lords, I make my submissions.
So, are you supporting the 17 Act, the Amendment Act?
Yes. Exactly. Yes.
You're supporting it.
Yes.
So that's not exactly neutral.